Administration says that they're focused on finding criminals. Worst of the worst, they say. But many of the people the DHS is arresting in Minnesota have no criminal history. That fits a pattern. In 2025, 93% of the people arrested by ICE had no violent criminal history, 65% had no criminal convictions at all, and randomly stopping people in the street because their skin color isn't the one that they expect or want isn't doing a thing to help public safety. I've heard the administration talk about fraud. No, not the 43 fraud convictions the president has or the $43 million fraudsters the president has pardoned, but instead saying that ICE is here to look for fraud somehow. You know, we work with federal government all the time.
That states may separate their sports teams based on sex in light of the real biological differences between males and females. States may equally apply that valid sex-based rule to biological males who self-identify as female. Denying a special accommodation to trans-identifying individuals does not discriminate on the basis of sex or gender identity or deny equal protection. All of that remains true, even assuming a man could take drugs that eliminate his sex-based physiological advantages. The law is reasonably tailored, regardless of whether it is perfectly tailored as applied to any such tiny subset of men. And states are not required to redefine sex or monitor the testosterone levels of female athletes. In short, male athletes who take performance-altering drugs are not similarly situated to female athletes, and states need not treat them the same. I welcome this court's questions.
Would you elaborate on what you alluded to, and that is that whether or not a state has to, its asserted interest in classifications has to bear out in each individual case? That seems to be what the applied challenges in individual cases would require.
That's right. So intermediate scrutiny requires a substantial relation or a reasonable fit, which is not a perfect fit. And this court has recognized, and I'd point this court to Edge Broadcasting in particular, it focused on this exact issue of if the law is substantially related in general, can an individual come in and say, well, as applied to me individually, it's not. And the court said, no, we're not going to allow you to do that because that would essentially convert intermediate scrutiny into strict scrutiny on an as-applied basis. Now, I'm not disputing that you can sometimes bring as-applied claims under intermediate scrutiny. So if, for example, you had a law that applied, this sort of law that applied to sports, but also math and also chess, it might be that as applied to math or chess, it was invalid, but it was valid as to sports because for math and chess, at the level of the classification, it's not reasonably tailored. But here, critically, everyone agrees that for sports, for 99% of men, it's reasonably tailored. It's just the 1% of trans-identifying individuals who take drugs and then those drugs are effective that's a problem. And this court's decision in Michael M. makes clear that that's not a viable as-applied claim. In Michael M., this court upheld a statutory rape law that applied differently to men than women, and the rationale was because women faced a unique risk of pregnancy. But of course, if either the male rapist or the female victim was infertile, there'd be no pregnancy. So on their theory, you could have come in and said, well, I have an as-applied claim that I was infertile, so it was okay to rape the underage girl. And this court not only rejected that, the court said it would be ludicrous to say that you could bring an as-applied claim for prepubescent girls. That's just not the way as-applied scrutiny works in intermediate scrutiny cases. That's equally true, as my friend said, in Wynn. In the court's decision in Wynn, the justification for the law was making sure that the parent knew that they were the parent and had an opportunity to have a relationship with the parent. But Wynn's father knew about the birth, was present with Wynn the whole time, and brought Wynn to the United States. Nevertheless, the court held for the class of men overall, it was reasonably tailored, and they weren't going to focus on the specific facts of Wynn.
You started, Mr. Mupon, by saying that you can did think that there were as-applied equal protection challenges, and giving an example of, well, if it had also applied to the chess team or something. But that doesn't seem like an as-applied challenge to me. That seems as though there's just a provision of the law that's facially invalid, right? So let's put those kinds of cases aside where you can split the law up and say this part is facially invalid, this part isn't, and focus instead on like real as-applied challenges. Your classification is basically okay, let's posit, because there's a substantial relationship to your goal. Is there ever a time where a person can come in either on behalf of herself or on behalf of a subclass and say, notwithstanding that there is no a valid facial challenge here, there is an as-applied challenge, this subclass has to be exempted?
So I don't think this court's cases have ever squarely addressed that. I think if it could be brought, it would have to be a very substantial percentage. So to give you a stylized hypothetical, if you had a law that regulated on the basis of sex, and you could imagine 3 subgroups of males, for subgroup 1 and subgroup 2, each of whom were a third of men, it was reasonably tailored. But for subgroup 3, which was a third of men, it wasn't. Maybe in a circumstance like that, the third subgroup could come and say, for a third of the applications of this law, it's not reasonably tailored. That's not enough of a substantial fit, at least for us, even if you're going to uphold the law for the other 2/3 of
But why does it have to be that many people? Why? I don't understand why that subclass can't make this showing and get the remedy as to them.
Because if it's one person, you're basically converting the law into strict scrutiny.
But you're not. You're not. I mean, because what you're doing is you're allowing that individual to get the remedy that we've said in cases like CASA is the only thing that's available, that you can't have this flow to everybody. It's just about this individual and whether or not he's been unconstitutionally treated.
So again, because if the law is reasonably tailored for 99.99999% of people, and you come up with the point fraction of percent and say that that person has a viable claim, that's more than you would ever require under strict scrutiny. I don't know if any.
No, but I mean, well, what's the result of that? If you're making a facial challenge, I understand that you're saying that if the law has such a broad sweep of constitutionality, then we're not going to strike this thing down just because we can identify one person for whom it doesn't apply. But if you are that one person and you can show that this is unconstitutional as applied to you, I guess I don't understand why it matters that it's constitutional as applied to 99.9% of the other people.
Well, because I think you're begging the question when you say it's unconstitutional applied to you. Laws that classify on the basis of sex only need to be reasonably related. And so if it's reasonably related because it's tailored for 99% of people, then it is constitutional even applied to
Even
you.
as applied to you. So you are
Yes.
saying there is no such thing as an as applied intermediate scrutiny
no,
challenge.
again, if there was one where it was a third of the people, I can maybe understand a claim that the third of people, it's not reasonably related for them, even though it is for 2/3 of the people. I'm just saying that when the numbers get as small as they are here, that claim's not viable, and we know that from this court's cases. Again, Michael M., every infertile man,
No, I understand, but we didn't do that same kind of quantitative analysis in Caban, right? We didn't ask the husband in Caban to figure out where he stood relative to all husbands who were to whom this was applied.
Right. So yeah, let me talk about both Caban and Lair. So
Please.
Caban is not an as-applied challenge. Caban did not say that there was some set of people for whom that law was valid. The differential treatment on
Itself, Lair said that about Caban.
So what Lair held was the father in Lair had abandoned the child. And what Lair essentially said is, if the mother had abandoned the child, the mother wouldn't get a veto.
Can I read to you what Lair said about Caban? Discussing Caban, Lair explained, quote, "We have held that these statutes may not constitutionally be applied in that class of cases where the mother and father are in fact similarly situated with regard to their relationship to the child." So Lair is interpreting Caban as an as-applied challenge, isolating a subset of people where there's not actual similarly situated circumstances, and Lair is different. It is a facial challenge. It is in opposition. No?
That sentence in Lair, the facts of Lair, there was no differential treatment. The father and Lair had abandoned the child, and the court basically rejected his claim because if a mother had abandoned the child, the mother also wouldn't get a veto. So Lair's a case where the plaintiff lost because there was no differential treatment at all. Cabana is a case where the plaintiff won because the classification couldn't be justified. The only way those cases would support their position is if either Cabana or Lair had said there is some set of cases where the woman gets a veto but the father doesn't, and that's fine. And neither Cabana nor Lair said that. This court has never said in those line of cases that the mother could get a veto but the father doesn't, and that's perfectly okay. So that's what they're arguing, and neither of those cases support it. You would also ask about VMI, so if I could just briefly address why VMI doesn't support them either. In VMI, the point was, yes, lots of women wouldn't want to go to VMI, but also lots of men wouldn't want to go to VMI. As to the set of people who were actually burdened by the exclusion, all of the women, the law was not fairly tailored. The argument that Virginia was making VMI was essentially equivalent to the following. If MIT said, most women and frankly most men can't meet our math and science standards, so we're just not going to allow women to come to MIT at all. Of course this court would reject that argument. That was the argument that they were making in VMI, that just very few women wanted to attend. But for the set of women who wanted to attend, the law was not properly tailored because there was no justification for excluding them.
Thank you, counsel. Justice Thomas? Justice Alito?
Under Title IX, what does the term sex mean?
We think it's properly interpreted pursuant to its ordinary traditional definition of biological sex, and I think probably given the time it was enacted, reproductive biology is probably the best way of understanding that.
Thank you.
Justice Sotomayor?
The problem I'm having with what you're doing now is you're doing exactly what Justice Stevens said should be done, and he admitted later in O'Connor that the court roundly rejected that in Caban and Lear. He wanted to do exactly what you said. He said, in dissent, this court should be in analyzing equal protection, contending that if the classification is justified in those cases in which the rule has its most frequent applications, then it doesn't violate equal protection. And then he said the court should presume that the law is entirely valid and require the challenger to demonstrate that its unjust applications are sufficiently numerous and serious to render it invalid. It's exactly what you said we should be doing. So you want us to accept what the dissent did and not what the majority said it was doing in Caban or Major. In VMI, Justice Scalia said the same thing, that taking the majority's logic to its logical conclusion, a single woman who wanted to attend could satisfy the admissions requirement would be enough for an as-applied challenge, and that shouldn't be the law. You're asking the court to adopt views expressed by two minority dissenting judges in this case. We've been doing an awful lot of that lately, but you're smiling because it's true, but you're asking us to adopt an approach that we have rejected as a majority court and accept what dissenters are doing, correct?
With all respect, no. Again, in Caban, nowhere in the majority opinion in Caban did they say this law is reasonable for certain classes of men, but it's not reasonable.
It did exactly. It said it's reasonable for fathers who don't support their children. It won't be reasonable for fathers who don't.
With all respect, Your Honor, it did not. Caban did not uphold that law as applied to any man who hadn't abandoned their child. Now, it is true Lair upheld the law for someone who had abandoned their child, but the reason it upheld the law is because women who abandoned their child.
But the logic of the opinion is that if the reverse had been true, it would have ruled the way it did.
I don't think that's true, but even if you thought that was, sure.
No, I just have one last question. What's percentage enough? There are 2.8 million transgender people in the United States. That's an awfully big figure. I do understand that in Idaho, this was the first transgender child, but that just happenstance as to location. What makes a subclass meaningful to you? Is it 1%, 5%, 30%, 15%? One is not enough for you, but why?
Well, so I'll say.
When the numbers don't talk about the human beings.
So I'll say a couple of things about that, Your Honor. The first I'll say is if the distinction between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit, 1% surely has to be on the side that's reasonable. But if you don't want to just take the 1% on its own face, I would point your court, you want to focus on majority opinions or opinions for the court. Michael M. rejected a challenge even though that law wouldn't, for infertile either infertile rapists or infertile victims, the justification didn't apply. There are certainly more infertile people.
They did it on a different basis, which had to do with different harms.
No, that's not true, Your Honor.
Well, I can read the decision and tell you.
With all respect, that paragraph, it says, even setting aside the physical differences, it is ludicrous to think we have to exclude infertile children from this rape law. And there are certainly more infertile people than there are trans-identifying individuals who take these drugs and eliminate all their physical advantages. So if we just focus on holdings of this court, we know that this percentage is too small.
Justice Kagan?
Mr. Buban, just assume with me that there is such a thing as a as-applied equal protection challenge. What would it take to bring that challenge? What should the plaintiff have to show?
I think they would have to show that, A, they are a substantial enough percentage to be able to bring an as-applied claim, and then as to that group, the law wasn't reasonably tailored for them.
And that they would have the burden on that. It's not for the state to come back and say, the state does not have to satisfy that burden initially.
Certainly not the first of the two things I said. I think if you thought that you could have a valid as-applied claim and they had made it through the gate of saying they were a big enough class, then I think consistent with normal intermediate scrutiny, I think the state does bear the burden of showing justification for that class. So I think the state would have it on the second step, the plaintiff would have it on the first step.
I see. So they have to sort of get through the gate of we're big enough for you to take us seriously, but then the state has it.
I think that would be how you would analyze it.
And I think you were asked this, but big enough to be taken seriously? Like, how do we decide that?
You know, again, the court's cases haven't really talked about it. I think the way I would think about it analytically is the difference between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit. So is there enough of a group here that we think that we're not essentially holding the state to perfection? If it's so close to perfection, then you're really undermining the difference between the two. If it's a big enough group that we're not asking for perfection.
I mean, are you really undermining the difference between the two? Because usually we think of the difference between the two with respect to facial challenges. So you have to do a whole lot less to show that the facial classification that you're making is okay.
I don't think so. I do think that you would very much be undermining the difference between the two if you said that even a single person could bring an as-applied intermediate scrutiny case. And again, I would urge your Honor to read Edge Broadcasting. There's a whole section of the opinion that's on this exact issue and says exactly what I'm saying. Now, admittedly, it's a First Amendment case, but it's an intermediate scrutiny First Amendment case.
Thank you.
Justice Gorsuch?
If the class is big enough, in your discussions, say a third, as you discussed, might it just fail intermediate scrutiny facially? I mean, at some point, do they collapse?
So I agree that that's part of why these are so unusual. If there's a big enough group that you've excluded, you're exactly right. It might not be reasonably related as a whole, and so then it facially fails. But I could at least conceptualize a situation where it covers enough people validly that a facial challenge fails, but it covers a big enough group that it can't be justified for, then maybe you could bring an as-applied claim. I don't think this court really needs to grapple with these fairly tricky analytical questions because this is the world's easiest as-applied claim to reject. It is a fraction of a percent. Whatever as-applied claim you could bring, it cannot possibly be a fraction of the percent. That would be totally inconsistent with this court's decision, Michael M. and Wynn, both of which rejected claims by people who had a much greater percentage than a fraction of a percent.
As you know, a lot of states allow biological males who identify as female, transgender women and girls to play in women's and girls' sports. And you heard Idaho say that the states, those states, other states, constitutionally may allow that consistent with the Equal Protection Clause. Do you agree with that?
So we've been challenging those laws under Title IX in lower courts, and as we said in our brief, we would urge the court to just reserve judgment.
Can you answer the Equal Protection Clause question that I just asked?
I'm not sure if we've taken a position on the equal protection piece.
Do you have a position?
I don't right now.
Okay, and on Title IX, footnote 2 of your brief seemed to say that you don't have a position on how Title IX applies to those states as well.
No, so we are actively litigating in lower courts, and we are saying that they are violating Title IX. What the footnote says is it's a very different question, and we would urge this court to make clear it's not resolving that question one way or the other by what it says in this case.
Okay, so you have a position on it, but you don't want us to say anything about that issue.
It's a very different question analytically, and so—
I understand. That's why I'm asking.
Yes.
Yeah. Okay. Thank you.
Justice Barrett.
So, Mr. Mupan, when Justice Kagan started asking the questions early on about the as-applied equal protection challenges, she pointed out that there was kind of a surprising dearth in the case law really grappling with this. But I think you wouldn't be getting all the questions that you're getting about Caban and Lair and, Michael Lamb and VMI if it weren't the case that you can read some lines of cases either way. So let's say that there is this uncertainty. We haven't really confronted it. As far as I can tell, it's because it just wouldn't be relevant in strict scrutiny because it's often fatal in fact, or typically almost always fatal in fact. So it's really an intermediate scrutiny problem. Maybe it's a rational basis problem too. I mean, maybe this would have implications for all kinds of review. Because it seems to me that if you're never talking, in any case in which scrutiny is not talking about a perfect fit, you might have this problem. What would it do, essentially? I'm just trying to think about the ramifications of allowing as-applied challenges. It seems like it's at war with the theory of intermediate scrutiny for some of the reasons that Idaho said, because all lines, all classifications overshoot or undershoot, right? So can you imagine how intermediate scrutiny works? And this is, this isn't designed to be a layup or something. It's honestly just something I'm grappling with. How would it even work going forward?
So I'm not sure I can say a whole lot more than what I've already said, which is I do think it's a problem. The reason I think it's a problem is it's conflating the difference between strict scrutiny and a perfect fit, intermediate scrutiny and a reasonable fit. And I worry that if you allow as-applied claims to a small enough group, you're essentially collapsing the difference because you're essentially requiring a perfect fit. Because whenever you have a reasonable but not perfect fit, the subset who falls within that will come in and bring an as-applied claim. And so the state will essentially have to have perfectly tailored laws because any single person for whom you don't have a perfect fit could come in and bring an as-applied challenge.
Including, say, boys who just couldn't make the team because they weren't good enough, because the law, to the extent that it's designed to protect competitiveness and safety, et cetera, wouldn't pose the same danger in the case of a boy who just isn't good enough to make the male team, but perhaps could make the girl team.
At least arguably, depending on what their exact theory is for the justification.
Thanks.
Justice Jackson?
I guess I'm still struggling to understand why the state would have to have perfectly tailored laws. I would think the state would just have to make exceptions where people can demonstrate that the justification that makes the state's conduct constitutional doesn't apply to them.
So making exceptions is tailoring your law. That's literally what it means to tailor.
No, but from the standpoint of a facial challenge, when we're asking whether this law has to be stricken completely because it isn't, perfectly tailored. What we're doing is a different exercise in the as-applied challenge. We're asking whether, even though this law is overbroad, we're assuming it's overbroad now because you've got in there some people to whom it should not be applied. What do we do about that? What is the remedy that those people can get? And what I hear you saying is they get no remedy unless they can demonstrate that there are enough people that this is sufficiently overbroad that it's no longer something the state can do.
Right.
And I don't understand why that is. Why wouldn't, when we identify people for whom this law operates unconstitutionally, that's the premise, because now I'm in remedy, right? The premise is that you have a person who's successfully made an as-applied challenge. This, to me, unconstitutional. You say, too bad, unless you can show that it's also unconstitutional with respect to a sizable number of other people. And I don't understand why that's the case.
Because I don't agree with the premise that the law operates unconstitutionally as to an individual person just because the justification for the law doesn't apply to that person. That's what this court held in both Wynne and Michael M. It recognized that the justification that was put forward for the law might not be true for each and every person the law applied to, but this court said that's fine.
And if we read Caban and Lair to say something different, if I disagree with you, then we just...
Well, Wynne is the most recent of the cases. So
okay.
Even if you read the cases that way, and Wynne is explicit about this. Wynne explicitly says, I believe it's, I'm not going to get the page number right, but Wynne explicitly says that we recognize that there are some men who were present at the birth of their child, who have a DNA test to prove that they were the father, that have been with their kids their entire life. Yeah. In fact, that was probably true of Wynne's father. Tough luck.
Okay, so Justice Barrett is worried, I think she said, about the implications of allowing as-applied challenges. I guess I'm worried about the implications of not, because as Justice Kagan said, we have consistently said that facial challenges are really hard to get, that as-applied is really all there is. So now we're in a world in which you are setting up new barriers, in my view, to establishing an as-applied challenge. So at the end of the day, is your position that no matter how clear it is that the particular prescription is operating to disadvantage a particular group, that classifies you, treats you differently, you're just not going to be able to get a remedy for that individually anymore.
Let me take a step back, and then maybe this will help. Laws that classify, in general, are subject to rational basis review. Now, there's higher scrutiny for classifications on some things. For race, we have strict scrutiny. For sex, we only have intermediate scrutiny. What that means is it is okay to have a classification that doesn't operate perfectly for each and every person. So it's not the problem is that it's unconstitutional, but there's no remedy. The point is that it is constitutional,
I don't necessarily
even though
think
it's
that's
overbroad.
the takeaway. I think what that means is it's okay because we realize that in some circumstances, maybe even in many circumstances, this classification is justified. But when we can identify a situation in which it's not, I don't understand why a person can't bring that challenge.
Well, I can't say anything better than in both Michael M. and Wynne, the court recognized that there were people who wasn't tailored for and they didn't give them a remedy.
Thank you.
Thank you, counsel. Ms. Hartnett.
Mr. Chief Justice, and may it please the court, Idaho concedes that HB 500 draws a sex-based line by categorically excluding all students with the biological sex of male from women's teams. Sex classifications like that are closely scrutinized under the Equal Protection Clause to ensure they rest on evidence, not supposition. Idaho's articulated justification for this line is to protect women's sports from birth-sex males because of their, quote, biological advantages. That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth-sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage. This court's cases have recognized that when the government's justification for a sex-based classification does not apply to a discrete subgroup of those classified, that classification is unconstitutional regarding that subgroup. And that holding in Caban, which I'm sure we'll discuss further, has been repeatedly referred to and reaffirmed, including more recently than Nguyen and Morales-Santana. Because the court can affirm based on sex discrimination, it's not necessary to reach the question of transgender status discrimination. The HB 500 also fails on that basis. If the court does not find the case moot, the preliminary injunction should be affirmed. I welcome the court's questions.
Couldn't you make a similar argument with respect to Title IX itself and the sex difference, the fact that you can have male and female sports?
No, Your Honor. So I think the point would be, the question would be, would the sex line that's drawn in sports, and that's a line that does exist, as a commonplace line, is that substantially related to the important state interest?
Well, you could have individuals who, for example, don't present the problem of physically outmatching women in a particular sport, or a group of people who don't.
Right, and the broader goal here, of course, is not sex separation for its own sake. The idea is to have equality in sports, and that's the ultimate objective that I think we're all talking about, not separation for its own sake.
Well, my point is the argument that you're making now with respect to this subcategory, could it not also be made with respect to sex separation in Title IX generally?
Occasionally there have been examples of a boy challenging the separate teams because they want access to a team that's not available for the boys because of the way Title IX works. To be clear, we have not aware of an example of a boy challenging the sex separation so that they can be on the girls' team where there's a boys' team that exists. In that case, the courts do look at that under intermediate scrutiny, and they determine that the overall goal of ensuring equality in sport opportunity for women and men allows for the distinction.
Counsel, I wonder if you could address what has been, I think, the basic focus of the discussion up till now, which is, as I see it anyway, whether or not we should view your position as a challenge to the distinction between boys and girls on the basis of sex, or whether or not you are perfectly comfortable with the distinction between boys and girls. You just want an exception to the biological definition of girls.
Thank you, Your Honor. We're not asking for a particular definition or even really an exception. I think what we're asking for, and it is similar to the nature of the challenge that was brought in Caban. The situation there where there are unmarried fathers that were barred completely from objecting to their child's adoption. And there the father said, we'd like to be able to have that objection. We have a substantial relationship with the children. And the group, and there was actually a pretty tailored group in that case. In Justice Stevens' dissent, he points out it has to be an older child and there has to be a participation in the rearing. For that subgroup, they were allowed to challenge that and get the relief. And so, I do note too that Justice Stevens pointed out that it was an indeterminately small subgroup of an unknown number of fathers. So I think that's the analogy that we would draw here to what we're asking.
So what would be the appropriate inquiry? And it's asking you basically for your response to Mr. Mupan in particular, that going sort of challenge by challenge, whether it's based on a transgender status or anything else in the situation, is really transforming intermediate scrutiny to strict scrutiny.
We agree there would have to be a group. I don't think, in our view, in a way, at least the way that the cases have worked out, and this is Caban and Lair, it also goes through Nguyen and Morales-Santana. I would also direct the court to the illegitimacy or the non-marital children case. Those are Trimble and Lally. They're cited in the BPJ brief. In the same way, I think the court looks, is there a definable group that's not just a person who happens to not meet the fit, but actually a group where the rationale doesn't make sense for the subgroup. But the group can be somewhat specific. Like in the case of Caban, it was actually unmarried fathers who had acknowledged paternity and had a substantial relationship. In the Trimble case, it was non-marital children who had a confirmation of paternity and a relationship with the father.
Well, that sounds an awful lot like strict scrutiny, unless you're going to say whenever you can come forward with anything that is an exception to the boy-girl distinction, in any case at all, you can go forward with the strict scrutiny challenge, whether it's 1% or whether it's 12 people, and I'm just not quite sure, grasping why your position isn't really an effort to apply strict scrutiny to a distinction that we haven't applied it to.
Thank you, Your Honor. I mean, all I can say, and I do agree the cases are not that many in this context. I think it's possibly because facial challenges were more in vogue before, and now as-applied challenges are more preferred, and so that may be explaining why a statute in Caban, for example, wasn't viewed as carving out the statute for the people it couldn't be applied to versus facially invalidating it. But I do think it matters because it's not just a matter of fit that makes intermediate scrutiny different. There also has to be an important government interest, not a compelling one, and this is really critical. You can burden the right in intermediate scrutiny. So in Nguyen, for example, that person failed because he actually didn't take the steps that would be needed to confirm the paternity. So you're allowed to actually, he may have had a compelling case on a one-off basis that, hey, I actually do have that relationship with the citizen father when I was born abroad, but he didn't take the steps that he needed to do. The same thing with Lair, and the same thing with Lally and the Trimble-Lally line. So you can actually burden the right by saying Lindsay Hecox has to actually submit testosterone tests or something else different than other people, and that would not be allowed if it were strict scrutiny.
And if we follow your approach, which allows a challenge to even a fairly small group that's affected, in what way would we not that would apply across an entire range of things where there's a distinction currently between boys and girls, quite apart from just athletics. Is that correct?
Your Honor, I do think that the question would, I think we're not trying to invent something here. I think we were trying to draw from what we understood to be precedent from the court, and I would direct you to the Equal Protection Scholars Brief. They have some scholars that have actually focused on this question of what does an as-applied challenge mean in the equal protection context. But I think taking a step back, the question always would be looking at what the state's asserted interest is here. And here the state is not asserting an interest of having the boys' teams be better and the girls' teams be worse. What they're trying to do is control for a sex-based biological advantage. And so I think a lot of the hypotheticals that you can maybe understandably think about, what about the untalented cisgender boy? What about the transgender woman who didn't mitigate? You know, what about this or that? That gets taken care of because the testosterone is the advantage on this record, and almost all the people that might want to try to get an as-applied challenge under some other idiosyncratic framework would not be able to show that their exclusion actually was.
Okay, and this will be my last question for. My point was more that how we approach the situation of looking at it not as boys versus girls, but whether or not there should be an exception with respect to the definition of girls. That would, if we adopted that, that would have to apply across the board and not simply to the area of athletics.
I mean, I think it's a general framework for equal protection challenge. Again, predated this case, this litigation. There have been boys that have tried these challenges in the past. They generally have failed because they actually don't lack the opportunity, or actually they're not being treated differently than similarly situated individuals.
You said, Ms. Hartnett, that you're not talking about individual by individual by individual. It has to be a defined group. So how big does the group have to be? How does it have to be defined? And why are there those requirements? If what you're saying is right about equal protection law, why wouldn't it extend to individual by individual by individual?
I don't think the court has foreclosed that, other than this actual obvious conceptual question of, like, when do we get towards strict scrutiny? I think what I could tell you is that in the way that the court looked at it, from Caban to Lair to Nguyen to Morales-Santana, and then also Trimble and Lally for the case of non-marital children, the court seems to usually be trying to figure out not just is this individual somehow idiosyncratic, but are they part of a group that actually doesn't make sense to exclude. And that makes sense because usually you're trying to figure out, is the interest served by the exclusion, and there's usually some principle why a subgroup was not properly included.
And what are the requirements of, what does that group have to look like? Mr. Mupon suggested that it has to be, fairly sizable. It can't be 1% or less. Why not? Why? What are the other requirements? Like, how do you go about defining which group, which subclasses get to make this challenge and which subclasses don't?
That's a good question, Your Honor. I think in Trimble, this is again the non-marital children case and cited in the BPJ brief, they said discrete categories that were unnecessarily excluded. That was the notion there. So I think that's where we were trying to make clear that we don't think it can just be, we have a person that is extraordinarily idiosyncratic and they should get their case. And I don't think anything in your cases rules that out. I guess that's not actually the case presented here. We think we have an easier case because we actually have identified a discrete subgroup, transgender women who do not have an athletic advantage.
But I don't think you're answering Justice Kagan's question, which is fine. If you buy into you have this subgroup as you've identified it, Mr. Mupon says that subgroup has to be big enough. Do you agree? And if so, how do we evaluate that?
I don't agree with that. I think that is I think in a way this is the Caban dissent kind of coming back after many decades, because there, Justice Stevens said in the dissent, he's assumed that the case in that case was assuming that the case extended only to himself and by implication to an unknown number of fathers, and went on to say indeterminately small part. So I think there's never been a numerical requirement. It's more of a question of whether there's a principle, that some sort of a principle that allows for the exception in light of the failure to align with the interests that the state's asserting. And here, I think the record, and again, we're at a preliminary injunction stage, but the preliminary record was that the exclusion of our client actually was not going to advance the interest, nor the exclusion of other transgender women who do not, who have taken efforts to mitigate their testosterone, which was on the record here again, was the main driver of differential athletic performance.
Counsel, one might wonder whether the efforts to refashion our equal protection jurisprudence here that we've been discussing at length on sex discrimination is really a fallback from what one might wonder might have been your primary argument, which is that transgender status is itself a discrete and insular class. And I'm curious why you haven't brought that up and what thoughts you want to share with us. Your friend on the other side said the laws you pointed to in your brief don't address transgender persons as such, and that makes all the difference. Thoughts?
Well, thank you for the opportunity to address that. I think we were trying to find the most straightforward way to help the court to an answer here, and I think we do think
I've been wondering what's straightforward after all this discussion.
No, I understand. I think these are older cases, but it's very interesting to see the debate between the majority and Justice Stevens, and then Justice Stevens and O'Connor kind of admitting that he was applying his dissent in Caban. So these are cases from the court. We think they have some force. But to the question you've asked, I do think it's important to begin with, you heard my friend on the other side talk about cross-dressing or other laws. They didn't have any response to our point, because there isn't one, that transgender people were categorically excluded from immigration to this country under an overall umbrella of being a psychopath. That was the actual decision of this court in the Boutelier case. It was an interpreting language of Congress that determined that when Congress used the term psychopathic personality to exclude people, they meant to include homosexuals and other sex perverts.
Perhaps not our finest hour.
Well, it's not your fault, but I think that.
Thank you for that.
No. Well, it was by reference to a congressional report. They were trying to figure out what did Congress mean, and there actually was a public health service report. I would direct your attention to it because I think it really does go to the level. I was surprised when I read this document. It's 1952, USCAN 1653 at 1701, trying to explain why sex perverts would include homosexuals, transvestites, which was the name of the day for transgender people. The term transgender did not become more common till now. So I think reading Boutelier and reading the USCAN that's cited in Boutelier is instructive. I also think that the laws on cross-dressing, I think that's an interesting point, because what that actually means as a practical matter for the transgender person was that they weren't allowed to leave their home as themselves to enjoy all of their civil rights. And we don't want to exaggerate it, but we also don't want to understate it. There were major cities in the country, Chicago, others, that actually barred you under subject to criminal penalty for leaving your house in clothes that weren't matching your gender. And people were actually prosecuted under those laws. So again, I appreciate, and we're not saying you have to have the same history. We're certainly not equating the experience of the transgender community to that of Black Americans or of women. But just as illegitimacy or non-marital children has been recognized as a class that gets closer look, I think we respectfully submit here it would make sense to do so. We appreciate, though, this is a question that the court hasn't recognized a suspect class for a long time. They also haven't shut the door to a suspect class since Cleburne. So I think we prefer, to the extent the court was still finding another path forward, the reason why we tried to help you find a way to answer the question here based on sex discrimination.
Well, to pick up on the issue of discrimination on the basis of transgender status, let me go to some basics. Do you agree that a school may have separate teams for a category of student? If it does that, then is it not necessary for there to be, for equal protection purposes, if that is challenged under the Equal Protection Clause, an understanding of what it means to be a boy or a girl or a man or a woman?
Yes, Your Honor.
And what is that definition? For equal protection purposes, what does it mean to be a boy or a girl or a man or a woman?
Sorry, I misunderstood your question. I think that the underlying enactment, whatever it was, the policy, the law, we'd have to have an understanding of how the state or the government was understanding that term to figure out whether or not someone was excluded. We do not have a definition for the court. And we don't take issue with we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth sex males categorically from women's teams, and that there's a subset of those birth sex males where it doesn't make sense to do so according to the state's own interest.
Well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes?
I think here we just know that we basically know that that they've identified pursuant to their own statute, Lindsay qualifies as a birth sex male, and she's being excluded categorically from the women's teams as the statute. So we're taking the statute's definitions as we find them, and we don't dispute them. We're just trying to figure out, do they create an equal protection problem?
All right, suppose this school that has a boys, let's say, track team and a girls track team. The school has that. And a student who has the genes and the reproductive system of a male and had those at birth and has never taken puberty blockers, never taken female hormones, never had any gender altering or affirming surgery, says, nevertheless, I am a woman. That's who I am. Can the school say, no, you cannot participate on the girls' team?
Sorry, so you're just a birth sex male who has all the advantages of birth sex male hormones, and can the school bar him from the women's team? Yes, they can.
But that person, is that person not a woman in your understanding? If the person says, I sincerely believe I am a woman, I am in fact a woman.
I think
is that person not a woman?
I would respect their self-identity in addressing the person, but in terms of the statute, I think the question is, does that person have a sex-based biological advantage that's going to make it unfair for that person to be part of the women's team? And that's the rationale for the regulation, and so that's the way we would be testing that hypothetical.
Well, the reason I'm asking has to do with discrimination on the basis of transgender status. So what you seem to be saying is, yes, it is permissible for the school to discriminate on the basis of transgender status, because if this person is a trans woman, a trans girl, and is barred from the team, from the girls' team, then that person is being subjected to differential treatment based on transgender status, right?
Well, that would be, then the question would be whether it was, the scrutiny would be satisfied. So from our perspective, that would be a transgender classification. It would get heightened scrutiny, and it may be satisfied here because of the need to have, to curtail unfair athletic advantage. That would be the analysis. We are not pressing in this case the notion, and the case does not require the court to decide whether transgender women who've gone through puberty and have not suppressed their testosterone would be able to play on a men's team. And the record here is a preliminary one where that doesn't present that question for the court.
When this does present a particular factual situation, and we have to decide that case, but looking to the broader issue that a lot of people are interested in, there are an awful lot of female athletes who are strongly opposed to participation by trans athletes in competitions with them. What do you say about them? Are they bigots? Are they deluded in thinking that they are subjected to unfair competition?
No, Your Honor, I would never call anyone that. And I think what we're saying here is that you have to, that's the reason why there is intermediate scrutiny, or even in rational review, you don't legislate based on undifferentiated fears. You base on trying to make a rational response to what is a perceived issue. I think here, although I would take issue with the notion that there was no reference to transgender individuals in the creation of this law, I really would direct the court to JA. Again, this is not about animus. I'm just saying that if you look at JA, pardon me, I need my JA 105 through 112, there are numerous references from the sponsor of the law saying the way we're going to try to protect women's sports is to not have transgender women play on the women's teams, and that was the fear that they had at the time. Again, that is not an accusation of animus. It's just a question of what was the statute doing, and then we go to the point of, does the statute survive heightened scrutiny? That would be the inquiry.
Do you think that the success of trans athletes in women's sports is proportional to the percentage of trans athletes who participate in women's sports?
I think I would direct your attention to, there's a, I want to make sure I have the right amicus. There's an amicus brief that talks about actually some of the there are examples, obviously, of some transgender people that have participated and excelled. They actually are few and far between. You know, we have our client here who tried to make the NCAA team because of the injunction. She was too slow. She played club soccer, club running. She was even an officer in one of those clubs, just doing what you would hope a college student would do. You'll hear from my colleague about the other case. But I do think that, and there's a brief that you, in the amicus briefs, that will share the examples of showing that's a bit overstated.
Would the analysis be different if they were more successful?
No, I think it would be, to the extent, I mean, we've already covered that transgender people are a meaningful slice of the population, but a small slice. I think the state, if there were a concern of women's sports being fully overrun by an outbreak of a huge new number of transgender people, that might be a different factual situation. In the end of the day, and we understand, that there were legislators who were concerned about that. The legislative history makes that clear here. But that wasn't the factual basis before the court. If there were actually a threat to women's participation in women's sports, that could be a different analysis, because obviously the goal of sex equality in sports is a very important goal. We don't take issue with that. We just would say that I think this is an important moment to just take a step back and say, is this law actually responding to a problem in a rational manner, or is it actually overreacting on the presumption that transgender women are categorically going to be strong athletes when that's not the case?
Well, just to put the big picture, and you know this, on the table, and let you respond to it, but obviously one of the great successes in America over the last 50 years has been the growth of women and girls sports, and it's inspiring. And there's some states in the federal government and the NCAA and the Olympic Committee, so these are a variety of groups who study this issue, think that allowing transgender women and girls to participate will undermine or reverse that amazing success and will create unfairness, because you said if large numbers, well, for the individual girl who does not make the team or doesn't get on the stand for the medal or doesn't make all league, there's a harm there. And I think we can't sweep that aside. And I think that's what's undergirding some of the concern in this big picture, and there are harms on both sides. So I completely understand that, but I just want to let you respond to that, because that is, the NCAA, the Olympic Committee, a lot of states, federal government, that's a lot of people who are concerned about women's sports and think this raises a big problem, and I just want to make sure you can explain that.
Thank you, Your Honor. And just to be clear, Title IX is a huge triumph, and I'm a veteran of women's sports myself. So I'm glad it exists. It's made a huge difference in our society. That's not what we're talking about here. But I do think, to the point of, for the podium question, I think the question is there an unfair biological advantage? That would be the question. So I understand the point. If there is somebody who's coming in with an unfair biological advantage, that would undermine the entire point of separate sports in the first place, which was to allow women to have a place to thrive, to be strong, to win, not to just be the B team. The question in this case is if the person had actually mitigated their sex-based advantage, which maybe interestingly, maybe counterintuitively, actually is more about circulating testosterone after puberty than a lot of the other things we might think are sex-related, then that girl that's come in second to a transgender person that's mitigated actually may just have come in second because the transgender person was similarly situated but was stronger in that one competition. That's why we are here not proposing a rule of absolute inclusion, but saying that in the case with people like our client who have mitigated, their exclusion doesn't match the statutory interest.
Counsel, can I ask you a question about analytically in the discrimination on the basis of transgender status? Since trans boys can play on boys' teams, how would we say that this discriminates on the basis of transgender status when its effect really only runs towards trans girls and not trans boys?
We understand the point, and I think that might be relevant to for example, animus point, right? There were not a complete exclusion of transgender people, there was an exclusion of transgender women. But I think on that piece, this court has never required the whole class to actually be excluded to look at the cases, whether the exclusion of a subclass was...
I'm talking about for triggering intermediate scrutiny if transgender status is a suspect class.
Right, so like Craig B. Bourne, for example, that's the one about the men that couldn't get the 18 to 20-year-olds, right? That wasn't all men, it was a subset of men, and yet the court still viewed that as a sex classification subject to heightened scrutiny. And likewise here, even though it's just transgender women, in our view, that are being barred and not transgender men, that also would trigger heightened scrutiny. And I think there's the Rice v. Cayetano case from 2000. There's other examples of the court making clear that just because a subset of the protected class is being excluded, you still would apply heightened scrutiny.
Another question about the science. So you were talking about circulating testosterone being kind of the marker. Idaho is saying, well, that's not the only indication. There are other, when I asked the question about 6-year-old teens before that there are other just kind of genetic hardwired differences, maybe in size, et cetera, that don't have to do with circulating testosterone. Is it your understanding that testosterone is it?
So, and my colleague who will present the argument in the next case, is that the record there was more about prepubertal and puberty. Right. I think that the 5% even is not clear whether that's just environmental or biological, actually.
Right.
But I do think, so there are other things that I think, like height, bone size, there have been some other discussions of this. This is an underdeveloped record, by the way. This needs to go back and have a full trial, except that it's moot. But I think the point there is that, no, I'm not trying to make a point on that. I'm not trying to pretend that I'm going to have a trial when we're not. Yeah. But I think the point is that sometimes counterintuitively, it's like having a larger frame, but not having the muscle and the testosterone to drive it could actually put the person in a worse position. And that's a study that was commissioned by the Olympic Committee. It's footnote 6 of our brief, indicates that actually it could be put the transgender woman at a disadvantage if they happen to have larger bones and less testosterone or muscle to drive those bones.
Last question. So below, as I understand it, your client challenged the verification procedures.
Yes.
Except when we were talking about how this might be administered, I understood you to say that it would be by checking testosterone levels, because it would be okay to say, to Justice Alito's hypothetical about the cisgender male who has taken no steps and who is now trans, to exclude that person. But would that be an invasion? Would that be a violation itself, or too invasive to require someone to, and maybe not just once, but maybe to periodic testing to make sure that the circulating testosterone was low enough? Why wouldn't that be invasive?
So that's an ordinary blood work that a transgender person would get, and that's why I think it's of the nature of the minimal burdens, like in Nguyen and the other cases where the court has said intermediate scrutiny applies, and you actually can, if there's minimal things you have to do to make yourself fall in the category that we want to keep protected, we can require that of you. But
didn't you challenge it?
Well, that was different actually, because the 3 things that you'd have to prove under the state's novel verification thing would have to be your genetic, your reproductive anatomy, which would require actually like a pelvic examination or examination of someone's, nude area. It would be chromosomes, which would require chromosomal testing. That's not what we're talking about. Or it would be endogenous testosterone. And the reason why that wasn't a problem is not because of a blood test. It's not invasive. It's because it would have required the transgender person to stop their hormone treatment to get back to an endogenous level to be able to show they're endogenous.
Okay, so the distinction between circulating and endogenous.
Right, the point was that was actually in a way, like, and I'm not trying to cast aspersions, but a kind of a false requirement for transgender people, because they aren't on their endogenous testosterone when they're on hormone therapy. They're on a non-endogenous medical treatment.
Thank you, counsel. Justice Thomas? Justice Alito? Sotomayor?
I'd like you to address mootness, because you raised it with Justice Barrett. Is this case moot? Could you respond to the other side's positions or arguments as to why it wasn't? And how do you respond to that? Secondly, Justice Barrett did raise earlier, this law applies even to primary schools, correct?
Taking your second question first, yes. I don't think it's in the record whether or not there are any primary schools, whether they sex separate or not, but that is the law.
And so, at least as to that subgroup, no one could doubt that primary school children might have the strongest argument that there's no difference in their physical makeup that would cause harm or otherwise create an advantage, correct?
That would be our position, Your Honor. In this case, we had both our client who was at college at the time, and then we had a high school intervener who was worried about being subject to sex verification, so we didn't really get into the building a record on the
But the point is that the law might be overbroad in many ways.
Certainly, yep.
And there's still, as you noted, Idaho was the first or the second state to pass this law?
It was the first. I mean, these cases come to you because they're early ones.
And the record here was the most underdeveloped, correct?
Including because it was a preliminary injunction. There was a substantial amount of expert material in the record that allowed the district court to make appropriate findings, but it was not the level that you build out for a trial.
And both courts said that the record had to be looked at more carefully.
Expressly, they did.
All right, so answer the mootness question.
I mean, Your Honor, all I can say is that we've tried to provide the court with accurate information as soon as it came to pass. In 2024, when we opposed certiorari, our client still was active and intending to play sports. The court granted the case. She was preparing for what she hopes is her final year of college. She was concerned about the increasing hostility and the visibility. I mean, we're here now, and that's okay. She understands she brought the case. But that was the basis for her trying to end her sports career. And it isn't contrary to what she said before. She did intend to play sports through college. Her college has taken a long time. She's now sworn she will never play sports that are covered again, and she won't do that even if she happens to somehow win this case. So that is just the truth. But whether the court believes it's moot, that's, we put the facts before you for you to decide.
How about her graduating this year? There was a suggestion she might not.
As you can tell, we college students have so she is trying her best to get through college. I think at this point, and I'm just basing on what I know of as to today, she's unlikely to graduate by May, as my friend said, but is hoping to make through summer credits, could graduate in the fall.
Finally, in terms of the sports teams, the Olympic team, that all happened in 2025 after our president directed them to.
We do think that's worth parsing out. Again, there's been a lot of contentions made on both sides that are extra record, but I do think a lot of those things flowed from the executive order. There were some other sports orgs that were doing different things, but I think we have to be careful not to broad brush that, because some of it may have been political, some of it may have been scientific, and the record really isn't fully before the court.
Justice Kagan?
Ms. Hartnett, I just want to get your understanding of what constitutional review would look like in this context. So you said it's not individual by individual. You have to come in and say there's a class that's not being treated appropriately. What is that class here?
And thank you, Your Honor. And I would say I don't think the court has ruled out the individual case. I just think we weren't presenting it that way because we were trying to align ourselves with how the court had looked at it. I think we would say we represent the group of people that do not have an athletic advantage, that have mitigated their their biological advantage of being born male.
So who do not have an athletic advantage for reasons of taking certain medications or hormones or
no sex-based biological advantage. So it would encompass both people that had gone through the male puberty and had mitigated. It would also encompass others that have not yet gone through puberty or that staved off puberty with the puberty blockers.
And as to those people, who has the burden of showing that the justification doesn't fit?
I think I think once we've identified the subclass under intermediate scrutiny, it is the state's burden to show a substantial relationship for that group, and they failed to, and that's how those other cases proceeded.
You wouldn't think that because we are talking about an as-applied challenge to a law that's facially everybody can see is legitimate, that the burden should shift to you?
I don't think that's how the cases looked at it when they were assessing. They were kind of assessing whether the state had provided enough to allow the exclusion. For example, in Lair, the state had made an adequate showing to show why the parent in that case was properly excluded.
And how do you think the question of scientific uncertainty should play out in an analysis like this?
Thank you. That's a good question, and I know this was something the court did address in Scrimeti, a rational review case, but citing Carhart, which also talked about that. I think the one thing we definitely want to have is complete findings, so that's why we really were urging to have a full record developed before there were any final judgment of scientific uncertainty. I think the court has not fully grappled with what does scientific uncertainty mean and how does it come into conflict with heightened equal protection scrutiny, but I think we don't need to present that yet because on this record, there was not uncertainty. This person had mitigated testosterone was the determinant. Maybe on a later record that would come out differently, but I don't think that.
Just play it out a little bit if there were scientific uncertainty.
I mean, if it really were an equipoise, then I think that that is a situation where I think it's still heightened scrutiny. So under a heightened equal protection scrutiny, the burden is on the state to justify the law, and if they haven't been able to justify that, that usually fails. If it's really a question of they're at 50-50, do we allow the state some leeway? I don't think that's been answered in the court's cases. Normally, the heightened scrutiny controls, and there's not a deference on top of that in the equal protection context.
Thank you.
Justice Gorsuch?
Just to follow up on that, I wonder if that starts to sound like strict scrutiny, because if the point of intermediate scrutiny, of course, is some leeway for the state, not a perfect fit, at least in the facial area. But if there's scientific uncertainty about whether puberty blockers and testosterone suppressants completely or mostly or some percentage of the time eliminate all competitive advantage, some competitive advantage? I mean, you've been very careful, I think, and rightly so, to talk about mitigating advantage. But I don't know, does the state have to show that it eliminates advantage and it doesn't eliminate, some percentage of advantage remains in each individual case, or for the group as a whole? I'm struggling to understand your response to Justice Kagan on that score. Maybe I'm inartfully posing the question, but I hope you understand.
I do understand your question. I think the question is at some level, I think the question is where you have science that's developing in real time at some level, what happens, how does that dovetail with trying a state that's trying to regulate and do that? I think what we can say on this record is the categorical exclusion is really not supported, I don't think, by any science. This again was from kindergarten through college. And so there'd be some subgroups at least. And I think there has to be an effort to try to tailor it. I think here the problem was there was a reaction of transgender women, a picture of what that would be, kind of an undifferentiated fear, frankly, from the Cleburne case. And so I think
I appreciate all of that, but it seems to me from my glance at the record, and quite a record it is, that there is a healthy scientific dispute about the efficacy of some of these treatments, and that's understandable. And I'm just wondering, how does that fit with, assume there is some dispute, and I understand the record remains to be developed further, but how does that fit with intermediate versus strict scrutiny?
At the end of the day, it's the state's burden to show a substantial relationship, and I think in the case of something where they're doing their best and have the best evidence some evidence to support what they're doing.
Some evidence, the best evidence, exactly. I mean, that's
a level of evidence that wasn't met here. So the study and the findings. I mean, the district court made a really good point. That study had actually been retracted, and it didn't pertain to transgender athletes. So in a way, this is not the hardest case. I appreciate it as a hypothetical. I guess what I would just urge in this area that's sensitive, obviously politically, but also as a matter of science, to at least let a record develop in one of these cases that lets you decide, actually, is this
I totally agree with that.
50-50 versus 80-20?
All right, but 50-50, does the government win? Does 70-20 the government win? That's what I'm getting at. I understand the complexity of the record and the difficulty of the science, but if we're going to have individual cases brought, that's the kind of question we're going to ultimately have to answer. Not the science question, but the percentage question, if you will.
No, I understand that. I mean, VMI does provide some sort of a metric of what we would do there, which was we looked to see there were kind of evidentiary debates on both sides of that. But even if you could say that a lot of women may not have ever made the cut, the fact that there were some that did was enough to invalidate the entire policy. So I think there are ways for courts to make those judgments, and I think the court has not yet, I think, encountered a case where heightened scrutiny puts a heavy burden on the state. It's not an insurmountable one like strict scrutiny normally is. And then what happens if it ends up with the evidence being a tie or close to it when we go back to the trial court? I think that would be that would be breaking some new ground, because I don't think there's an equal protection case that decides that issue. Usually the evidence is kind of clear on one side or the other about whether the restriction is justified.
That would remain for us to decide at a later point.
I do think that's the most prudent, but definitely on a record that's more developed, because I think I think in the end of the day it might end up being a surprise to, we don't know yet, but I think we have some good evidence that actually at the end of the day, being transgender woman, actually to the extent there are, and you've repressed your testosterone, you're at somewhat of a disadvantage in many ways, because you have, again, this larger frame with weaker muscles and no testosterone.
Thank you.
Justice Kavanaugh?
Just to follow up on Justice Gorsuch's question, a broader frame about the role of this court when there's scientific uncertainty. I mean, there'll be different district courts who do different things, almost certainly in different cases, and in an area of scientific uncertainty where there's strong assertions of equality interests on both sides. And so it's going to come to this court, and we have to decide for the whole country, constitutionalize this. And I guess given that half the states are allowing it, allowing transgender girls and women to participate, about half are not. Why would we, at this point, just the role of this court, jump in and try to constitutionalize a rule for the whole country while there's still, as you say, uncertainty and debate, while there's still strong interest on the other side? And I think one of the themes of your argument's been the more people learn, the more they'll agree with you. At least I've detected that theme in your argument. So why would we get involved at this point and constitutionalize?
I understand the question, Your Honor, and I do think that the Equal Protection Clause's demands have never been viewed as kind of a, a separate avenue from the legislative process. They can and do often coexist. And here, I think the point is we have two as-applied challenges to early laws. They have their unique cases in their own right. I don't think this court needs to set rules forever on this area. I think the most important thing would be to allow a record to develop, even in areas of controversy. And we look back at what you cited in Scrimeti, you cited Carhart. There were extensive findings. There also were findings in VMI. There were findings in Craig v. Boren. I'm learning things by reading these cases over again. There were findings in those cases. And so I think that at least before the court decides to either step back fully or to embrace its role here of providing the scrutiny that should be attended to groups when there's a worry that the democratic process isn't actually going to fairly respond to their concerns, I think the point, at least at a minimum, would be get a full record, which we don't have here. That would be my request.
Thank you.
Justice Barrett? Justice Jackson? Thank you, counsel. Rebuttal?
Thank you, Mr. Chief Justice. A few points. I heard just a moment ago that there is no real threat to women's sports. We strenuously disagree. We cite your honors to the UN Special Rapporteur's report that says 600 women have lost 890 medals in 29 different sports. That's what we're talking about. It is a real threat. Medical transition does not reliably suppress all male athletic advantages. I'd cite your honors to our record in which our expert, Dr. Brown, shows the experience of one C.C. Telfer, an elite track athlete who underwent a medical transition and whose track times did not change. That is the story in many situations, and unless we can reliably distinguish between those situations and the situations which testosterone suppression does reliably eliminate the advantage, then we can't do that. We need a broader classification, and sex is the right one. And if it were merely politically motivated, I would add we wouldn't see this same rule being implemented by World Athletics, World Boxing, the NAIA, these different groups that were not influenced by recent politics but came to these decisions after studies, after lengthy examination, and reached the same decision that Idaho has. Justice Gorsuch, in your colloquy with Respondents' Counsel, she agreed with us that this is not the same as the discrimination that has been faced on the basis of race or on the basis of sex in this country. We agree it's not close to the discrimination that people have faced on the basis of race or sex in this country. That said, the court does not need to reach that answer here, because if there is no transgender status classification in Scrimeti, there certainly cannot be one in the case. In fact, as our briefs argue, the court can and should avoid all of these questions by applying rational basis review. Bottom line, sports are assigned by sex because sex is what matters in sports. It is the fairest and the safest and the most administrable way to assign sports teams. It's been widely accepted for many decades because it's necessary for fair competition, because where sports are concerned, men and women are obviously not the same. If Idaho can't enforce a sex-based line here in sports, where nobody disputes that biological differences matter, then no line based on biological sex can survive constitutional scrutiny. The court should uphold the Fairness in Women's Sports Act and reverse.
Thank you, counsel. The case is submitted.
Ladies and gentlemen, you are staying for the second case. Please remain in your seats.
Argument next in case 2443, West Virginia versus BPJ. Mr. Williams?
Mr. Chief Justice, and may it please the court. States have long assigned students to sports teams by sex. West Virginia is no different. Maintaining separate boys and girls sports teams ensures that girls can safely and fairly compete in school sports. The question today is whether this enduring structure can continue. It can. Title IX permits sex-separated teams. It does so because biological sex matters in athletics in ways both obvious and undeniable. The text, history, context, and structure of the statute, alongside regulations expressly authorizing what West Virginia has done, confirm as much. Respondent says that West Virginia schools can no longer designate teams by looking to biological sex. Instead, schools must place students on sports teams based on their self-identified gender. But that idea turns Title IX, a law Congress passed to protect educational opportunities for girls, into a law that actually denies those opportunities for girls. The court should not embrace that backwards logic. Aside from its problems with Title IX, the decision below constitutionalizes one side's view of a hotly disputed issue. But West Virginia's law does not offend the Equal Protection Clause either. The West Virginia legislature reasonably and rationally defines sex based on biology and acknowledged the physical differences that biology creates. Given those differences, the law satisfies rational basis review. And the state's law satisfies even intermediate scrutiny because it is substantially related to the important governmental interest in ensuring fairness and safety in girls' sports. Respondent attacks the law by searching for a transgender classification that simply isn't there. The law is indifferent to gender identity because sports are indifferent to gender identity. Ultimately, West Virginia's law, like the laws of at least 26 other states, simply preserves the enduring structure on which girls' sports depends. It should be upheld. I welcome the court's questions.
What's your view of what Title IX, how it defined the separated sexes, male and female?
So under Title IX, Your Honor, we would look to the ordinary understanding of sex at the time that Title IX was passed, 1972, and I think also relevant would be 1974 when the Javits Amendment was passed. And at that time, the ordinary understanding of sex was biological sex, consistent with the understanding of sex reflected in West Virginia's statute. I think that's also consistent, frankly, with this court's own understanding of sex and some of its own cases like Frontiera, where it likewise focused on things like reproductive function.
Well, with that definition, how would you square this challenge with the continued existence of Title IX?
So I think this challenge fails under Title IX, and in fact, it amounts to a backdoor attack on Title IX, in the sense that Title IX itself contemplates sex distinctions, and express regulations specifically applying to the context of athletics expressly contemplate the distinctions between sex of male and female sports teams.
In interpreting this definition, would it make a difference, or does it make a difference that this is a spending clause statute?
I think it absolutely does, Your Honor. Obviously, in the spending clause context, as this court has somewhat recently reminded lower courts, it's important for Congress to speak with an even clearer voice because of the contractual nature of the conditions that are imposed. States like West Virginia have to understand exactly the obligations that they're assuming in the context of a spending clause analysis. And so it amounts to effectively a canon of construction that requires that clearer statement in order for the condition to attach.
I would have thought that's an interesting argument, that this is spending clause legislation in Title IX, and Congress has to speak with a particularly clear voice, and whatever it's said here isn't clear enough. You didn't raise that argument. And there's an argument from your friend on the other side that you waived the argument, or forfeited at least.
Right.
And it sure isn't the lead argument in your brief. Help me out. Why?
So we, of course, start with the plain text of the statute, Your Honor, as this court has told us to do several times.
Yeah, well, I might start with the constitutional authority under which that statute was adopted, counsel.
I think that's equally compelling authority for our understanding of the, as you know,
why isn't it in your brief?
West Virginia is maybe uniquely a fan of clear statement rules, as Your Honor might know from past cases, but in the spending clause context, I think it is in fact the case that your court has repeatedly stressed that Congress has to speak that
I know what we've said. I'm wondering about what you didn't say.
So I think if you're looking at the way that West Virginia has characterized it, certainly we have made that argument and presented that argument to this court. I'd refer you to the topside brief. It's clear and centered under a clear heading. As I think what their suggestion is from the other side is that we didn't clearly enough phrase that argument below. We would take issue with that characterization. There was obviously binding contrary authority in the Fourth Circuit. And so I think strategically we decided not to make that the front and center argument because we understood that was dead on arrival in that particular court. But that's not to say that we waived the issue by any means. It's a canon of construction that continues to assist this court in its application of the text of the statute.
But, counsel, can I just ask you about this, though? Have we ever applied the spending clause's notice requirement outside of the damages context? Because here we're not talking about a situation in which BPG is seeking damages, and I thought that was sort of a crux of the spending clause analysis.
I will concede, Your Honor, that many of the cases that talk about this rise in the context of, or maybe even all of the cases
yes,
rise in the
thank
context. I'll concede as much, yes, Your Honor, but I don't think the court has ever suggested that the specific request for damages is the reason for its analysis, and I think that actually would be inconsistent.
But we would be having to address that, I guess, and extend it in this context if we were to take a spending clause tack.
I would respectfully disagree, Your Honor. I would say that just because the court hasn't done so before doesn't mean it's an extension per se. I think that what the court has said is that you view the language of these statutes as effectively contractual agreements. And I think that that same sort of contractual logic applies whether you're asking the state to pay out damages or whether you're asking it to take specific action under compulsion of that.
Who is the contract between here? And I thought the regulated party needs to know what it's agreeing to so it can consent, but here the regulated party is the schools and it's the state that's coming in. So I'm just trying to understand how the spending clause analysis works in this context.
So I think the state is certainly one party that does receive federal educational funds, but it's also the many other petitioners that stand before you, including the county school board and the state school board, are also petitioners in this case. I think there would certainly be, if anybody were clearly bound by the conditions of Title IX.
So it would map on, I mean, I guess I'm worried that this might actually implicate the question that we didn't resolve in Moyle, and so we'd have to kind of figure that out because it seems like it's a different set of facts than the typical spending clause application.
I think if anything, Your Honor, this is maybe easier than your typical spending clause analysis because you've got everybody from the state all the way down to the local county school board. Anybody and everybody who's involved in this case is a party to this action. In fact, you resolved a petition for cert from the Athletics Commission saying we're not actually a state actor, and the Fourth Circuit saw things quite differently. So I think there's really no concern in this case that you have an absent actor problem when it comes to the spending clause analysis. And ultimately, of course, if it's just a canon of construction, if you're looking for a clear statement, then I think it would apply regardless of the particular party who might be in front of you because the statute applies across the board. You know, the regulated party is going to be affected regardless of whether they happen to be in front of you in the given case.
Can I ask you
I'm sorry. I presume that if it's statutory construction, a canon of statutory construction, it's hard to say you can waive that?
It's very hard to say you can waive that, Your Honor, yes.
I just wanted to ask if, on your understanding of Title IX, you could have separated by sex classrooms in biology or math based on some evidence that you have that say men are better at math and science. What are the limits to your Title IX theory?
So I think your instinct there in part arises from the fact that we're skeptical of any notion that there are inherent differences. So I want to kind of acknowledge the real reality of this.
Well, your whole position in this case depends on there being inherent differences, right?
It does, and I think that that's exactly why discrimination in the Title IX context, where it acknowledges merely inherent biological differences, that's not discrimination, that's a distinction. And I think that's consistent with this court's longstanding understanding of what discrimination means. It looks to differential treatment of similarly situated individuals. So even in a case like North Haven, you're talking about differential treatment of similarly situated individuals. So if we're talking about in an athletic context, you're not addressing similarly situated individuals. And I think, again, the Javits Amendment and the regulations that flowed from the Javits Amendment are a realistic reflection of those meaningful biological differences.
The Javits Amendment gives you a reason in the sports context maybe
Right.
to do it. I'm just wondering whether, you know, your friends on the other side have basically conceded that Title IX allows sex-separated sports teams. So I don't know that we need to really get into that. I'd be a little bit concerned about what the ramifications of that might be. And the Javits Amendment in the context of sports makes a difference anyway. But more broadly, I mean, if a state produced some studies saying, listen, women's presence in, calculus is holding men back because they're so much more capable and they can just move so much more quickly. Seems to me like there'd be some risk on your understanding that that would be okay.
I think, again, realistically, Your Honor, that would almost certainly fail on the lack
Well, how about chess club?
A chess distinction, I think, again, might fail because there's an actual lack of evidence of meaningful physiological differences that are reflected in the existence of the express regulations in the athletics context.
I mean, I think a lot of people would say, if you look at the ranks of chess grandmasters, there are not a whole lot of women there. And, what does that mean? Well,
I think...
I think that there's a sort of intuitive... I think there are a lot of chess grandmasters who would tell you that women just for whatever reason, they're not as good as this.
I think chess is an interestingly closer question. I've come to understand just recently, in fact, that there are sex distinctions in the elite.
You're fighting the hypothetical, and I guess the question really is, okay, Title IX says you can't discriminate on the basis of sex.
Yeah, sure.
I understand what that means. I think I do, right? Can't treat men and women differently. Okay, all right, fine. You're saying, but it matters whether they're similarly situated, and your friends in the government like that line too. Well, there's, I got a lot of evidence that girls perform a lot better in high school than boys. Okay, there's a lot of scientific evidence, or whatever, or let's just posit that, all right? Well, so I'm going to have a special remedial program for boys, and the women can't come, and because they're not similarly situated. Why on earth would Title IX care about that? It says you can't discriminate on the basis of sex in a program or activity of your educational institution.
So I think...
Why put that gloss on it?
And, Your Honor, I want to be clear. I think the task for the court today is somewhat easier in part because of the express regulations that they have actually not challenged and that do expressly contemplate exactly what West Virginia has done. So I think... Your hypothetical, yes, of course, is there, but I think the reality is that Congress and the agency have together kind of addressed this specific question in a way that makes this court's task much easier. But I think the problem may be with
Maybe another answer, we don't need to rely on this similarly situated argument? Is that what you're trying to tell me, counsel?
I think you could also take that approach, yes, Your Honor. And I think the reality is that that hypothetical addresses a situation that's much closer to the sort of exclusion and the specific context that gave rise to Title IX in the first place. And so I think that the court would be much more legitimately concerned that that would detect the very problem that Congress is trying to head off in passing Title IX in the first place. But I think that really kind of puts the lie to the position that West Virginia is somehow discriminating because it's advancing the very same purpose that Congress itself was trying to advance in enacting Title IX in the first place. I mean, that's why West Virginia somewhat deliberately made its law mirror the exact same language from the express regulations themselves.
I'm afraid I've got one more question. Oh, I'm sorry. Please go ahead. No, you're...
I can do both.
You can't do both. That's not fair. That's not fair. I mean, even by our standards. You make the argument that on the basis of means solely because of. Solely. We have long said that because of means but for, not solely because of. The Rehab Act speaks of solely because of. It seems to me an awful big stretch, counsel, to say that on the basis of imports anything other than but for causation. And, Comcast is against you there. And I just wonder why you put your eggs in that basket.
So 3 answers, Your Honor.
And by the way, isn't the distinction here solely because of sex anyway?
Well, let me take each of those in turn, or I'll try. I don't think that the case turns on the court accepting the idea that it's solely on the basis of sex. So I think you could stop.
That's a sufficient answer right there.
Fair enough.
Thank you. Your turn.
Thank you.
Can you explain the relevance and significance of the Javits Amendment to distinguishing sports from all these other hypotheticals?
So I think the relevance and significance is Your Honors are faced with a unique set of regulations in that Congress was directly and intimately involved in both the instigation of the regulation in 1974 and then sort of...
And in that law referred to the nature of particular sports, right?
It did. So what they said was, we want you, the agency, Hugh, to go ahead and implement Title IX writ large, and call that one specific problem that I think arose on the floor about whether Title IX applies to intercollegiate athletics, in particular intercollegiate athletics. And I would say...
And that's been extended to high school by the regulations. But ruling for you on sports does not open the door, in my view, given the Javits Amendment, to the chess club necessarily. That could be separately analyzed, but it doesn't follow from a law that says sports.
That's exactly right, and that's exactly why we were trying to make your job easier in the sense that we took the language expressly from the regulations and mapped it over under our own statute. So there's really no debate. If it's outside the context of Title IX, then it's outside the context of our statute. So at that point, the court's analysis is done. But I think when you have a regulatory scheme where Congress was specifically involved, in fact, undertook a review, then that's exactly the sort of regulation that even in a post-Loper Bright world continues to have importance because it's long-standing, continuous, contemporaneously issued, all those sorts of check boxes that this court, under a Skidmore framework, continues to place substantial weight on. So I think that makes the court's task relatively straightforward.
And what about Bostock?
No.
You want to deal with Bostock?
I think... So I guess it depends on the way in which you mean it. Does it deal in Bostock?
If an employer said we're going to fire all the transgender women, that'd be a violation. If a school says we're not going to allow the transgender women to play sports, you say that's not a violation. Both statutes use the term sex. Can you explain?
I think the reason why is, well, to be clear, our statute is very different from a specific choice to say a transgender person shall not participate because of their transgender status. And I think that really is what makes the difference between this case and Bostock, is Bostock is attacking status-based discrimination, and West Virginia would, I think, be in a much different position if we had just said transgender persons shall not compete. But that's not what West Virginia...
What if it said transgender women and girls shall not compete in women's and girls' sports?
I think, again, that's a much closer question. I think if we're talking about engaging with the actual status...
You think you could lose under Title IX with a statute that said that?
I think Bostock, is, now I understand Your Honor's question. I think Bostock raises an interesting question as to whether that reference to transgender status would in turn implicate the sex status that Title IX is meant to address. But ultimately, I think the court doesn't need to address that because you can stop at the first step, right? You don't have an actual transgender exclusion that would give rise to that kind of linkage of analysis.
Thank you, counsel. In terms of Bostock, I understand that to say that discrimination on the basis of transgender status is discrimination on the basis of sex. But the question here is whether or not a sex-based classification is necessarily a transgender classification. And I wonder if that is consistent with your understanding.
It's entirely consistent. I would say on the equal protection side in particular, and also in the Title IX context, I think for some of the reasons I just discussed with Justice Kavanaugh, I think the court can stop and say that a sex definition and a reference to biological sex is not the same as a transgender classification. And I think even if we engage in the sort of but-for causation analysis, I think it's as simple as saying, does the result change if you change the gender identity of the individual involved? And the reality is, if you apply the West Virginia statute to someone identifying as a biological boy identifying as a boy, applies in the very same way as a biological boy identifying as a girl.
Justice Thomas? Justice Alito? Justice Sotomayor?
I find it strange that the district court and the court below did find a Title IX violation, but not an equal protection violation, and remanded for the equal protection violation. I'm not sure how it could do that, because it would seem to me that if the evidence is not sufficient to justify finding an equal protection violation, it's not sufficient to find a Title IX violation. Is that correct? At least on the record as it exists now.
Right, and so to be clear, the district court actually ruled for West Virginia on both Title IX and so the Fourth Circuit said, you lose on Title IX and we're not sure about equal protection.
But let's assume the Fourth Circuit is right.
Right. Well, so in answer to your question, I think that doesn't make sense. And I think the reason why it doesn't make sense is because the Fourth Circuit effectively stripped out what they said is Title IX doesn't leave room for any kind of justification or any kind of analysis of what the reasons might have been for the state's action. And I think respectfully, particularly when you look at the regulations themselves, that actually does contemplate exactly that sort of analysis.
I agree with you on the regulations.
Right.
And so Could you not have a Title IX violation but still have? Let's assume, and I know you're going to fight the factual premise.
I'll try to embrace it, Your Honor.
All right, embrace it. All the scientific evidence showed that there's no difference between cisgender girls and trans girls. I know there's a fight about it.
It hurts.
I know it hurts. But assume it. Could you not still have violated? Could we hold that as the regulation stands, the regulation would permit you to discriminate, but the equal protection clause would not?
So let me try to get my head in the framework of assuming.
Assume.
I think the regulation would still allow us, under its express terms, right?
I'm assuming
Right.
yes.
And so you're asking, even assuming our compliance with the regulation, could we still have a potential equal protection problem?
Yes.
In that world, I think we would still be fine under the equal protection analysis, frankly, for some of the reasons that you heard from the solicitor earlier today, where it's because even if you assume the heightened level of scrutiny, let's assume that we're in an intermediate scrutiny world, it's still a reasonable fit. It's not a perfect fit.
Then we're back to that.
Exactly. And
right.
I know we've had a long colloquy about that today, but ultimately I think that's what
I just destroyed that by saying that the science has said there's no difference.
Well,
and we know that's not true. But assuming the science said there was no difference,
right.
How could you ever say it's reasonable?
So I'm assuming a world in which there's no difference between, so you're saying testosterone suppressed individuals? Is that?
No,
or you're saying all men and women full stop?
Right.
Oh, okay. I apologize for misunderstanding the hypo. If we're assuming a world in which there's really no biological difference, full stop, as to men and women, full stop, then I think, right, the legitimate governmental interest falls away. I agree with you.
Justice Kagan? Justice Kavanaugh?
There are, as we've discussed, a bunch of states that allow biological males who identify as female, transgender women and girls to play women and girls sports. We were talking about that with the Solicitor General earlier. On your theory of Title IX,
right,
are those states violating Title IX rights of the biological females?
I think it's a much closer question under Title IX than it is under equal protection. And I think the reason being is that the regulations specifically say there's
what do you think the answer is under equal protection? I might as well ask that.
So under equal protection, I think we agree with our friends in Idaho that there's enough room for California to make a different determination.
Okay.
I think under Title IX, the reason why it's a closer question is because of the existence of the regs. And the regs start by saying you start with co-ed teams, and then you can move down to sex-separated teams in the context of contact and competitive skill. And it really contemplates a real, genuine sex distinction in that move down B provision. Mm-hmm. And then, of course, it pivots. It also has the catch-all where it says, but actually in the contact sports, you can't even, you can't move back in the co-ed world. So I think if a state is moving away from a genuine sex distinction as the regulator contemplated and as Congress ultimately contemplated, then maybe they're kind of, if you think of B as a safe harbor in a sense, they're outside the scope of that safe harbor, and now they're running into the problem in A. So I don't think the court needs to get into any of that.
Right, I agree. I'm just trying to know what's coming.
But I think that it's a closer question at least than the equal.
Because your theory is that sex is biological sex in Title IX, or is that not your theory?
No, that is, and it's not our theory, Your Honor. It's just it's the ordinary understanding of what sex meant, both in 72 and 74 when the regulations were themselves implemented. So I think we're just trying to be consistent with that.
Thank you.
Thank you.
Justice Barrett? Justice Jackson?
So I guess I'm trying to puzzle through whether or not there is some independent form of discrimination against transgender women that is distinct from the sex separation that Title IX allows. So I appreciate that your argument is that because the regulations permit sex separation and that hasn't been challenged, that should be the end of this inquiry. Basically. And I think you get there because you say you're sort of picking up on this idea that maybe this is just about a definition of who is a male or a woman. Is that right?
I think to some degree, but it's also, Your Honor, it's just because we're indifferent to a person's gender identity in applying the law.
But the law actually operates differently, I think, for cisgender women and transgender women. That is, with respect to their desire to play on a team that matches their gender identity, cisgender women can do it, transgender women cannot. And so we do appreciate a distinction, I think, that is being drawn on the basis of your gender status, gender identity status, trans or cis, right?
So, and I want to make sure I understand
Yes.
if we're operating in Title IX world or equal protection world, because I think it might make a difference to the answer. But
Okay. Let's start with Title IX.
So Title IX, I think the question of, I look at this statute and see a distinction between boy and girl indifferent to gender identity. And I think that...
Right, but I'm testing that proposition, right? You see that distinction, and I see it too on the separation of teams level at the beginning.
Right, and I think what I'm hearing is that that distinction arises from a difference in effect, and I don't see a disparate impact analysis that's sort of hidden away in Title IX.
But why is that a difference in effect? So it's like a second order discrimination, right? The first order is separating male from female.
Right.
The second order is separating transgender women from cisgender women, right?
Respectfully, I would disagree,
No.
Your Honor. The reason why is just because I think anytime you have a classification, you could divide it into subclassifications, and I don't think that then becomes, like, the law in the same way applies to brown-haired biological girls and blonde-headed biological girls.
No, I understand, but I don't think you can
classification
get,
based on hair color.
I'm not sure, and maybe this is switching to the equal protection, I don't think you can get out of the implications of making a classification by setting it up as a definition, you know, as a subclass. And so we've already okayed the classification because it's really all about classification. You can't distinguish in that way, right?
Well, I think what the court said on the equal protection side is you look at the facial classification, and I think here it's effectively unconceded that the facial classification is between boy and girl. And I think at that point, if maybe you have a situation where you think that the classification is somehow a proxy for some sort of secret secondary classification, but I don't hear them suggesting that.
The definition implicates another division. So here's an example. So suppose we have Title IX exempting, and I think it does this, certain religious institutions from its requirements. And let's say Title IX defined, then went on to define, this is in my hypothetical, religious institutions to include only those institutions that proselytize. I mean, is that a classification problem or a definition problem? I would say it would be a classification problem, and you'd still have to apply all of the heightened scrutiny just because, you know, they're defining religious institutions in a certain way. Similarly here, you have the overarching classification, you know, everybody has to be, play on the team that is the same as their sex at birth. But then you have a gender identity definition that is operating within that, meaning a distinction, meaning that for cisgender girls, they can play consistent with their gender identity. For transgender girls, they can't.
So I think that, okay, so as to the part about your ability to pass over from boy to girl, where
yes,
you can go from one way but not the other, I want to be clear that BPJ is not challenging that specific classification. I think that's important to start with. But I think, if anything, that's useful evidence as to the lack of a transgender-based discrimination, because if the legislature were just sort of unsettled by the notion of transgender athletes, I think the answer would have been to then bar them from passing over in any way consistent with their gender.
I appreciate that. I guess I was getting at the what I understood the Chief Justice to be trying to discuss, which was this notion that this is really just about the definition of we accept that you can separate boys and girls, and we are now looking at the definition of a girl, and we're saying only people who were girl assigned at birth qualify.
And there is authority cited in our brief. This court, I don't think, has ever phrased it quite as in the way of this definitional framing that we're talking about right now, but certainly cases like Jana Rock in the Second Circuit do approach it from this sort of definitional framing, and they say that if you effectively concede that there's an initial ability to draw a classification, then that suffices to satisfy the intermediate scrutiny question. But then past that, the definitional question is evaluated through rational basis review, and that's Jana Rock. I recognize this court has never gone as far as that, but I don't think the court needs to go as far as that because, again, I think the way that you would do the analysis is to start by looking to the face of the statute. And if the face of the statute is engaged in a conceded boy-girl sex classification is conceded to be legitimate, then at that point, you kind of know which world you're operating in.
Thank you.
Thank you.
Thank you, counsel. Mr. Lupan?
Mr. Chief Justice, and may it please the court. So there have been a lot of different arguments made this morning, and so I think it might be helpful to just focus on what I think are the easiest way to resolve both of the claims in this case. On the equal protection claim, it's the arguments we discussed this morning about intermediate scrutiny doesn't work on this as-applied basis. So let me focus for the Title IX claim. I think the simplest way to resolve the Title IX claim in this case is as follows. The regs expressly authorize sex-separated teams. The other side isn't challenging those regs. When those regs use the word sex, they obviously use the word sex to mean biological sex in the reproductive biology sense. That's the ordinary meaning of the term in 1972 and 1974. As a result, whether or not they are right that taking testosterone suppression eliminates any physical advantage doesn't matter because the regs define separation based on sex, based on biology, not based on circulating testosterone levels. So the difference that their claim that they've eliminated the difference just doesn't matter under the language of the regs, and that's enough to resolve the case.
So your argument, as I understand it, is that they're not similarly situated.
So that's an additional argument you could make is to say that even if you just focus on the language of the statute says discriminate on the basis of sex. Discrimination, as this court has repeatedly recognized, including in Bostick, means treating one person worse than someone who is similarly situated. And yes, we don't think a man taking performance-altering drugs is similarly situated to a woman, but you don't even have to reach that question because under the regs, the question is the regs say you could separate based on sex. Everyone agrees that sex in those regs means biological sex. Therefore, the circulating testosterone levels are just legally irrelevant under the regs.
So why do you say you can separate the sexes? Why are you now taking the position in other cases that if states choose not to separate the sexes in the way you want, that they're violating Title IX?
Well, so again, we think that's a separate question and you should leave it separate, but the argument we're making in those cases is the statute and the regs allow separation based on sex because of the biological differences between men and women. If you purport to separate based on biological sex, but then you allow some biological males to play on the female team, you've undermined the justification for separating in the first place. Because normally you can't separate. If you take, for example, world history class, you can't have world history class for men and women. That's generally prohibited by the statute. The reason you could separate for sex for sports is the biological difference. And if you then undermine that, you've undermined the justification for separation.
So we're now back always to the science. Is there really a difference? And a difference for this kind of person? If it's not clear the way you want it to be in terms of separating the sexes, I'm wondering why it's clear for your attempt to force those states who are choosing not to do this. You're now saying you must.
Again, that question is not presented in this case, and for this case, the factual dispute is irrelevant.
Mr. Mupen, do you think that the spending clause should inform our analysis here?
I don't think this court should invoke the spending clause in this case.
Why not?
For two reasons. One, we think that the statute and the regs clearly do not permit the claim.
I understand that.
And then the second is how the spending clause applies in the context of Title IX is, I think, a little more complicated than my friend suggested. It's not a clear statement requirement. I think if you look at some of these clear notice cases like Jackson and Geyser, I don't think you would say that those statutes had a clear statement.
It's a clear notice requirement.
Right, but how that applies is a little tricky, and I think in the case...
Why? I mean, your argument is that in 1974 and 1960, sex meant biology, and that there's not clear notice otherwise. Why isn't that the end of it?
Again, so I think the end of it is the statute clearly doesn't permit this claim. I'm just saying that I would be cautious about speaking about how the clear notice requirement applies because it is not a clear statement requirement.
I understand that. You're not answering my question with
how
respect.
So I guess
if it's a clear notice requirement at minimum and a voluntary agreement, And sex at the time of the statute meant, as Bostock said, you know, there's a good argument it's biology. And why wouldn't West Virginia be within its rights to say we didn't have clear notice otherwise?
The scope of the clear notice requirement is a tricky question. If you look at this court's cases, I suspect—
What's tricky about that?
I suspect Your Honor would think a lot of the cases where this court has found Title IX to apply, you would think there's not clear notice.
All right.
And so I think it's a tricky issue,
All right.
and I think it's a case that should be briefed, and I don't think it's an issue you need to
Okay,
solve in this
and
case.
then on the statute itself, it speaks of discrimination in program or activity, and in Davis we explained that that requires kind of a look at the whole of the institution, because the definition of program activity is the whole institution. And so that's less individual focused, it seems to me. Thoughts?
Well, I think that's true for the funding, but I don't think that's true in terms of how the discrimination provision works. If you discriminate or exclude in one part of the school, I don't think you could justify that by saying, well, all the rest of the school, we treat everyone fairly. I think those cases you're talking about, as long as you're receiving funding somewhere, the whole school's activities are covered.
Okay. And so it really boils down to the living accommodations provision, which Congress anticipated there would be sex-separated living accommodations being permissible, the Javits Amendment, and then the regulations that are long-standing and then therefore are entitled to some serious consideration.
Well, no. So, you know, Your Honor asked why we run the similarly situated argument. Take, for example—
No, don't bring that back up.
Well, locker rooms and showers aren't covered by any of the things you just identified. Not the living facilities provision, not the Javits Amendment. None of those things cover locker rooms and showers. So unless you use a similarly situated requirement, you would have to say that Title IX bans single-sex locker rooms and showers.
Okay, all right. If that's your view, then let's talk about the similarly situated. I guess I have to. What about the hypothetical I posed earlier that when it comes to high school performance, girls are sure a lot better than boys, and so we're only going to have remedial classes for boys and girls aren't free to attend?
So I don't think those differences are based on inherent biological differences.
Well, let's say I've got really good science. I mean, it's all about the science, right? I got the science. You're fighting the hypothetical.
I'm not fighting that. I think what I would say, Your Honor, is that this court has held in cases like VMI that in general, classification based on sex is impermissible because in general, men and women are similarly situated. Where that's not true is for the sorts of real, enduring, obvious differences that this court talked about in cases like VMI, the differences in reproductive biology. I don't think the sort of pseudoscience you're suggesting has been baked.
Well, it's not pseudo. It's good science.
That's pseudoscience to say boys' brain development happens at a different stage than girls' does.
Well, with all respect, I don't think there's any science anywhere that has suggested that these sort of intellectual differences are traceable to biological differences, and I don't think the statute
with
should be read
respect,
to
I don't
cover
think you're a PhD in this stuff, and neither, I know I'm not, but I'm asking to deal with a hypothetical.
And so I guess what I would say about that, Your Honor, is—
I mean, the statute says no discrimination on the basis of sex. Right. And you're saying, it's okay when they're not similarly situated. And I'm giving you, you're worried about locker rooms, great, I appreciate that, but I'm worried about that math remedial class or the chess club or whatever.
Right, and so look, let me put it this way. The general rule is you have to treat men and women the same. And
I would have thought that's what the statute says.
And I think you have to be very careful about recognizing an exception. And so when you recognize an exception for what's similarly situated, I think you should tether it to the sorts of long recognized differences that would have been recognized at the time the statute was enacted. At the time the statute was enacted, no one would have doubted that it said it didn't require—
Oh, I think at the time the statute was enacted, 1964, there are a lot of people who thought boys are better at certain things than girls at others that we don't believe anymore.
Not based on inherent biological differences.
I think that maybe in 1964 they did.
And if they did, they didn't have any basis for it. Whereas for—
And I'm giving you a hypothetical where I have the science to prove it. And you're saying it's still not good enough.
I guess if you're asking me a hypothetical where the science existed in 1972 and everyone agreed with it, then it might be a different inquiry. That really is a hypothetical because there wasn't—
do we have to, I mean, I think these are very, very hard questions. I started with the math question before. I mean, but do we have to, because of the Javits Amendment, because the other side has conceded that Title IX permits sex-separated sports, Can we avoid your whole similarly
Absolutely.
situated argument that you run? Because I don't really like it that much either.
Absolutely. That's why when I stood up here, the first thing I said was the easiest way out of this case on this claim is to say that the regs permit sex separation. They don't dispute
Save
that.
locker rooms and all that.
Right. The only reason I went into it is I was nervous that any sort of suggestion that there isn't a similarly situated requirement could lead to results that I don't think the court would actually stand up to, like locker rooms and showers. And so I think I have no problem if the court doesn't take a position on it one way.
Okay, and I'll say, I said I don't like the argument. At first blush, I don't like it. I'm not trying to prejudice anyone making that argument later, but I think it opens a huge can of worms that maybe we don't need to get into here because the Javits Amendment and the concession.
That's right. As long as you don't cut it off the other way, I think that's perfectly fine.
Thank you, counsel. Justice Thomas? Justice Lee? Justice Sotomayor? Justice Kagan?
Mr. Mupon, you talked about you are litigating this case the opposite way among states that do not prohibit trans women and girls from participating in sports teams. Is that correct?
Yes.
So, and you said, and I appreciate this, that we should not address that question. Are there arguments that do suggest what the answer is on that question that we should be careful about? Or do you think that they're really self-contained boxes?
I think they're generally distinct, and what I could confidently say is the argument that I identified at the outset and with Justice Barrett just now, if you just say that the regs mean sex doesn't mean circulating testosterone, and therefore you're not required to allow boys to play on girls' team regardless of their circulating testosterone level, that argument would not influence the outcome of those other cases one way or the other.
Are there any arguments that would influence the outcome one way or the other?
I don't think so. Maybe if you engage in discussion about what the regs meant with respect to things like equal opportunity, that might be the sort of issue where it might have implications for the other case.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
I just want to be crystal clear about that. If we say sex in Title IX is biological sex, and then we get to the next case, the California case or whatever it is, how would California still prevail if we've said that here?
I think the argument the other side would make would be that the regs don't prohibit them from accommodating transgender individuals. Even though the regs permit separation based on sex, they also don't forbid accommodation of transgender individuals. That's the argument they would make. And they would say it doesn't matter that you're allowing some boys who have a biological advantage to play on the girls.
What's the argument you're currently making in opposition to that?
That the justification for separating on the basis of sex is the biological difference. And so you're undermining the justification for separation.
Right, and so we start with the separation. I think what you're saying is once you separate boys and girls teams, which everyone does, and it may be even required in my view, to have equal girls teams, then California really doesn't have an argument if we say that sex in Title IX means biological sex, which may be okay. I just want to make sure I know what we're doing.
Look, Your Honor, obviously we don't think they can argue that, but I'm confident that California would stand up here and say that even if you ruled the way I just urged, they should be able to argue the opposite by saying essentially that they're allowed to accommodate on the basis of gender identity, even though the regs mean sex and sex means biological sex. That's the argument they would make. Whether that argument's right or wrong is for another case, but I don't think if you adopt the argument I'm making here today, their hands are going to be tied.
Okay, and then on this premise that has been conceded, I just want to make sure I understand your view. My understanding is that it's sex-separated sports teams, so long as they're equal opportunity for girls and boys, are perfectly constitutionally permissible. Is that not your understanding?
Yes.
Yes.
Per the arguments in both cases.
I mean, it's conceded, but it's conceded because it's obvious, right?
Right, because there are obvious biological differences between men and women, and that's why.
Well, the why people may debate, but it's obvious, it's conceded, and so too Title IX, because of the Javits Amendment, at least, even if not Title IX originally.
Well, I would say even without the Javits Amendment, because importantly, the Javits Amendment is only about intercollegiate. So.
And it's been interpreted in the regs, so to go to high school and no one's ever challenged that part. That's the part, okay.
Right.
But that also sex-separated sports teams are perfectly permissible under Title IX, at least with the Javits Amendment, and probably without, correct?
That's right.
And that's conceded, but that's, it's conceded again because everyone accepts that and has accepted that for a long time, so long as the opportunities for boys and girls, men and women are equal.
That's right. And I think what the other side in this case is trying to do is say, yeah, that's fine, but they're being excluded. And the problem with that is they're not being excluded from participating on the boys' team. They're choosing not to participate on the boys' team. Now, for understandable reasons, given their gender identity. But the state is not excluding them from the boys' team. And Justice Sotomayor, this explains the confusion in the Fourth Circuit's opinion, because I agree with you. It is very strange that the Fourth Circuit.
Okay, we got it back. Sorry. You can, finish that off. Sorry.
The reason why the Fourth Circuit found that there was a viable Title IX claim, even though they said that there was a factual dispute, is because they bought into this notion that because the transgender boy doesn't want to play on the girls' team, doesn't want to play on the boys' team and can't play on the girls' team, they're excluded. That's true even if they have a physical advantage. And so the court said, we don't care about the physical advantage, it's still a Title IX violation. And that's clearly wrong. That's a misinterpretation of the statute. And the error in it is that they're not being excluded from the boys' team, they're choosing not to participate on the boys' team.
Sorry, one more. Bostock does not control here because, fill in the blank.
Because the law doesn't classify on the basis of transgender status, it classifies on the basis of sex, biological sex. Just like in Scrimeti, the law there classified on the basis of age and medical treatment. Here, the law classifies on the basis of biological sex. The person's gender identity is wholly irrelevant to how the law applies.
Thank you.
Justice Barrett? Justice Jackson?
But they are being prevented from playing on the team that matches their gender identity, correct?
That's the effect. So let me use your example from earlier. You said there's a cisgender woman, she could play on the team she wants.
Right.
There's a boy who identifies as a girl, he can't play on the team he wants. Take that same boy and switch his gender identity, but say he still wanted to play on the girls' team. Say he was a very unathletic boy. He likewise couldn't play on the team. So it's not the gender identity that's keeping him off the girls' team, it's his biological sex. His gender identity is wholly irrelevant to it. Now, I agree with you, there's a very significant disparate impact on transgender individuals by this law, because they're the boys who are most likely to want to play.
Have we said that Title IX never covers that kind of disparate impact in terms of its discriminatory effect?
Well, it certainly doesn't cover disparate. First of all, I don't think Title IX covers disparate impact, period, because it uses.
But in terms of its discriminatory effect, I'm just trying to understand it. Is there something to this notion that that differential treatment in effect in this way could be something that Title IX cares about?
I don't think Title IX covers disparate impact even on the basis of sex, and it certainly doesn't cover disparate impact on the basis of gender identity.
Okay.
Thank you, counsel. Mr. Block?
Mr. Chief Justice, and may it please the court, BPJ signed up for school sports because she was an 11-year-old girl starting a new middle school who wanted to meet people, make new friends, and be part of a team. West Virginia argues that to protect these opportunities for cisgender girls, it has to deny them to BPJ. But Title IX and the Equal Protection Clause protect everyone. And if the evidence shows there are no relevant physiological differences between BPJ and other girls, then there's no basis to exclude her. In thinking through the Title IX claim in particular, it's important to distinguish between how Title IX operates as a general matter and how it operates outside the context of athletics. And I'm glad that we're doing that this morning. Instead of focusing on athletics, West Virginia argues more generally that this court's reasoning in Bostock does not apply to Title IX. To distinguish Title VII from Title IX, West Virginia argues that Title IX protects groups instead of individuals and applies only when sex is the sole cause of adverse treatment. That approach takes a wrecking ball to the text of Title IX and the structure of this court's anti-discrimination precedents. It would dilute Title IX's protections for everyone, not just transgender students and not just in the context of sports. West Virginia's law treats BPJ differently from other girls on the basis of sex, and it treats her worse in a way that harms her. Outside the context of athletics, that's all BPJ would need to establish a Title IX violation. But the Javits Amendment provides extra breathing room for reasonable regulations that take into account sex-based differences in athletics to provide equal athletic opportunity for everyone. West Virginia's exclusion of BPJ does not fall within that framework. Unlike the exclusion of a cisgender boy, excluding BPJ doesn't advance any interest in ensuring overall fairness and safety. And unlike the case of a cisgender boy, excluding BPJ from the girls' teams excludes her from all athletic opportunity while stigmatizing and separating her from her peers. I welcome the court's questions.
Doesn't your claim ultimately depend on the existence of sex-segregated sports?
Yeah, no, I don't think so, Your Honor. I think this is similar to Morales-Santana, where the claim was an equal protection claim.
Well, I mean, let's say there were no Title IX requirement for sex-segregated sports.
Yeah, well, if there were no Title IX requirement, and well, I don't think Title IX requires sex-segregated sports.
Well, permits.
But if there were no Title IX and all the sports were co-ed, then she wouldn't be subjected to disparate treatment on the basis of sex. So I think the claim is the discrimination, and it's perfectly possible to.
So doesn't that suggest that you're a subcategory of the sex of the relevant class of female athletes? Isn't that your point?
Yes, well, for the equal protection claim.
Well, but you're not. My point is that you're challenging a category that does not exist in the statute, but is dependent upon the existence of a category in the statute that you're not challenging.
Well, I wouldn't put it that way. I would put it the way as there's a classification that we think is valid as applied to most people, but is invalid as applied to a discrete subset of those people. But I don't think the success of that equal protection claim hinges as an a priori matter on the existence of girls' teams. There are lots of ways to remedy an equal protection violation.
But I think, given the way you phrased it, the question becomes a little different, because what it seems to me you have to establish is the basis for requiring an exception to the classification. You're not challenging the idea of having boys and girls separate sports. You're saying that you cannot exclude transgender girls from the definition of girls. And that's an entirely different question than the equal protection question.
I don't think we're arguing for an exception. I think we're bringing exactly the same argument in Caban. In Caban, the plaintiff wasn't saying this is valid for everyone, but I want an exception from it. In Caban, the plaintiff was saying this is valid for other fathers, but it's not valid as applies to me. So I just think it's an as-applied equal protection claim. I understand the court might decide those claims don't exist, but I don't think it's a claim asking for an exception. It's a claim saying it's as applied to them, it's okay, as applied to me, it's not.
Counsel, how do you get to a Title IX violation? I know exactly how you get to an equal protection violation, okay? When if you accept that the regulation does, by its own terms, permit sex-based separate sports, does permit schools to do this. What in Title IX explicitly or even logically says that you have to give transgender
Thank you. I appreciate
girls the same opportunity? Because the regulation said, it's not just the statute, it's the regulation say, you can create separate sex teams.
No, thank you. I take the point. I think there's always been a tension between the underlying text of Title IX, which protects individuals, not groups, and the regulations, which are authorized by the Javits Amendment and have special leeway to make some group-based measurements. But if you look at the rationale for the regulations, Hugh, when it issued the regulations, said that we think that our group-based method, which otherwise would have been completely impermissible for Title IX, adequately protects the rights of individuals. Because if boys and girls as groups are being given equal sets of overall opportunity, then every individual in the group also has a set of equal opportunity to choose from.
Yeah, I think that's the problem. And, you know, you're absolutely right to worry about the wrecking ball, but I think we've kind of taken a wrecking ball to that. There's no solely in the statute, all right? We're talking about individuals. But Javits changed Title IX and it said, sports are different. And we've got these regulations that have been out there for 50 plus years. And, normally Skidmore kind of comes in there. Forget about the spending clause, I guess. But maybe I'll ask you about that too. Why doesn't that make this case very different than Title VII?
Yeah, so I completely agree. The Javits Amendment is what makes this different from Title VII, and I'm very happy with however this decision comes out to have a decision that's focused specifically on the unique context of athletics as opposed to these broad arguments about Bostock applying to Title IX as a general matter. But I guess what I'd say is the regulations still require equal athletic opportunity. It's not a complete exception for sex-separated teams.
Yeah, but Javits says it can be reasonable.
Yes.
And do you dispute that the Hugh regulation that's been on the books for 50 plus years is reasonable?
I think it is absolutely reasonable as applied to cisgender students. I think that as applied to transgender students, instead of providing them equal overall opportunity, it's a complete exclusion from the program. And so that's our argument, that it's reasonable as applied in the context of cisgender people, but interpreting the regulations to authorize this sort of categorical exclusion that doesn't give BPJ an equal set of opportunities to choose from would be an unreasonable way to implement Title IX.
Okay, gotcha.
It's unreasonable as to all transgender students?
No, I think it's a combination. I think so. A reasonableness test, I think that requires some sort of ends means fit, and I think that exists when it comes to cisgender students. I think what makes BPJ's case differently from a cisgender student is two things. First, she doesn't have any of the physiological distinctions that justify the sex separation in the first place. And second of all, the harm to her is of a material different kind. It's one thing to say, we're not going to let boys play volleyball because they have all these other sports to choose from, or we're not going to let girls play football because they have all these other sports to choose from. It's another thing to say, you don't get any sports.
But in that argument, does it matter whether BPJ has a competitive advantage or not?
Yes, we think it does, and I appreciate the opportunity to clarify that we don't have any objection to vacating the grant of summary judgment in our favor. We did our best to defend the judgment below, but our argument before the Fourth Circuit for summary judgment was that there wasn't a genuine disputed fact about whether she had an advantage. The Fourth Circuit, sua sponde, granted summary judgment to us based on the theory that that fact wasn't material. That's never been our argument in this case.
So your argument depends on depends on her not having a competitive advantage because she's not been through male puberty.
Not just not been through male puberty, but also gone through a female hormonal puberty with all the physiological changes accompanying it.
But that the argument goes away if those facts go away.
Yes, absolutely. Which is at the beginning of the argument, Justice Kagan, you talked about this could be resolved based on a legal principle or based on the facts. And I really do want to make a pitch for the resolving it based on the facts because, look, if they're right about the facts, then we should lose. And the irony is that in order to win summary judgment in this posture, when there's a disputed question of fact below, is they can only win in this posture if we're right about the facts, and there aren't any advantages. And I don't think there's any need at this juncture for this court to issue that broad a holding when, according to them, once the evidence comes in below, we're not going to get past summary judgment. I mean,
you're not suggesting that we decide the factual question.
No. I'm suggesting that the case be allowed to be decided on remand on the factual question, which I think, like, this is an important issue. It may affect the whole country, and the court wants to get it right. And I don't think the best way to get it right is to rely on, cherry-pick studies or assertions in amicus briefs. I think the way to get it right is to let all the facts they're trying to put in the record actually be put in the record. And then we'll have the facts in front of us, and maybe they'll make the issue go away. But I think that's unnecessary to intervene at this instance with a sweeping legal conclusion to something that might actually be a narrow factual dispute.
Counsel, can you explain whether or why your theory would allow a cisgender boy who just couldn't make the boys' team? I mean, he doesn't have an equal opportunity, he can't play, there's no team he can play on, and let's say that his athletic ability can be shown that he has no competitive advantage and he wants to be on the girls' team. Why can't he on your theory?
I appreciate the question. I think I just want to be clear about what we think the justification for the separate teams is. We don't think the boys' team is for better athletes and you have a backup team for athletes that aren't as good. I think the purpose of the teams is to control for the variable of sex-based advantages so that talented women athletes have all the same opportunities as talented male athletes. But also, untalented male athletes should be compared to untalented women athletes. So they're not being separated based on how good you are, right? The whole point is to allow female athletes to have all the same opportunities as men by controlling for the sex-based differential that comes through puberty. And so that's why I don't think that the claim is the same there. I think that's what's happened here is by virtue of her medical care, BPJ has already effectively controlled for those sex-based advantages. And so she is completely in the position that she would have been if her birth assigned sex had been female. As opposed to a cisgender boy who's just not very good at sports, and if his birth assigned sex were female, maybe he'd be even worse, I don't know. But again, the purpose is to control for the variable of sex to provide equality, not to have a good team and a team for people that can't cut it. Now, I'm happy to address—
Can I ask a question on the law?
Yes.
On Title IX? I mean, I hate that a kid who wants to play sports might not be able to play sports. Hate that. But it's kind of a zero-sum game for a lot of teams. And someone who tries out and makes it, who is a transgender girl, will bump from the starting lineup, from playing time, from the team, from the all-league, and those things matter to people big time, will bump someone else. And so one way to resolve it, as you say, is the facts, try to figure out, is there really a competitive advantage? I think we're going to get a lot of scientific uncertainty about that, a lot of debate about that, a lot of different district courts. The other way on the law, one way on the law is, okay, well, sex in Title IX and in Javits meant biological sex, and it's up to Congress to adjust that going forward if they want, given, as you say, and your co-counsel said earlier, you know, people are learning more about this, and maybe there really is no advantage. Well, if that's true, and some states are operating under that basis, that's the way to go. But for now, at least the law says biological sex, and I think we have to recognize on both sides the zero sum. It's not like, oh, just to add another person to the team. That's not how sports works. It's someone else is going to get disadvantaged. So I just want you to address that.
I'm happy to, and I guess I have three answers. I mean, the first is I completely understand that many parts of sports are zero-sum, but this law isn't limited to zero-sum opportunities. So BPJ played on the cross-country team where there were no cuts. She came in near the back. It wasn't
but I'm sorry to interrupt, but you wouldn't have a different rule if she was finishing in the top 5.
No, but it wasn't a zero-sum.
Or if they had cuts.
But what I'm saying is in
this particular case, but usually with teams, I don't mean to, just don't want to get out of that. Usually with teams, they're cuts.
Yes.
Those mean a lot to people. There's starting lineups. Those mean a lot to people. There's who gets a college recruit. That means a lot to people.
Yes. I just want to say that there still are some areas where there are win-win solutions. I think even being able to be on practices with a team consistent with your gender identity instead of your sex assigned at birth can be enormously important. So I think some scenarios are zero-sum, but not everything having to do with sports is. And I do think that one of the vices of this law is that it sweeps so broadly that even win-win solutions are taken off the table. In terms of aspects where it's zero-sum, no one likes to lose. No one likes to not make the team. And people often don't make the team. The cisgender girls don't make the team when competing against other cisgender girls all the time. And the question, I think, is whether it's an unfair advantage to not make the team because a transgender girl participated. And if there is no sex-based biological distinction, distinction there, then I think it's an unfortunate situation, but I think it's the unfortunate situation that comes with having a zero-sum game, not inherent unfairness. Then the third thing is, I think however the court resolves this case, I really urge the court not to do it based on a definition of sex argument. We are not disputing in this case that West Virginia can have its of sex. Our argument is it's using this definition to inflict discrimination and deny equal athletic opportunity, but we are not saying their definition of sex is wrong. However, I don't think it follows that Title IX created some national definition of sex that preempted states' ability to say, you know, actually we are most concerned about discrimination that happens through gender roles.
Can I ask you something? That's a very important point here, I think, for what happens in the future, what you just said. Do you think sex in Title IX can reasonably be interpreted to allow different states to take different understandings of that in their sports leagues?
I do, because I don't...
Why is that? That's real important, I think, going forward.
Right. Because I don't think the purpose of Title IX is to have an accurate definition of sex. I think the purpose is to make sure that sex isn't being used to discriminate by denying opportunities. Just as I don't think we need to define race in order to enforce Title VI. So I think I wouldn't look to whether or not it's accurate to classify, you know, BPJ as male or female. I think the question is she being denied an opportunity because of that classification? But obviously sex can mean more than just
So if we didn't want to prevent a different state from making a different choice from West Virginia, what should we not say, or what should we say to prevent that from happening?
Well, I wrote down the answer to that when you asked Mr. Mupin. I have two things. I wrote, don't give definition of sex, and I also said I wouldn't decide this by assuming that Title IX provides a right to single-sex teams. In the regulations, single-sex teams are optional, they're not mandatory, and in addition to that, we're talking about the regulations, but on the ground, the way this plays out in practice is you have a 1979 policy statement, a sub-regulatory document that has a complicated test for determining when a sex-separated team is or is not required. And so I think that both because I think saying there's a right to a sex-separated team would predetermine some of the questions in that other case. That's one reason why I don't think you should do that. But second, I think the more the court gets into questions that are handled in these complex regulatory documents, I think the more I'd be worried about this court accidentally saying something about how Title IX works that doesn't actually map on to how it is actually playing out on the ground.
Title IX prohibits discrimination on the basis of sex. It's a statutory term. It must mean something. You're arguing that here there's discrimination on the basis of sex. And how can we decide that question without knowing what sex means in Title IX? I mean, it could mean biological sex, it could mean gender identity, it could mean whatever a state wants to define it to mean, but it has to mean something. How can we decide that without knowing what the statutory term means?
Well, I think there are a whole range of sex-based characteristics that can give rise to discrimination. I think if someone said, I'm going to discriminate against anyone who acts in a feminine manner, like anyone with limp wrists, I don't care who they are, but I'm going to discriminate against them. I think that would be sex discrimination. It would be sort of gender presentation. But I wouldn't say that's not covered by Title IX. And so I'm not saying that biological differences aren't part of sex, but I'm saying that sex also has broader connotations, and there's no reason to keep that out of the statute. And I'm certainly not saying that sex means gender identity. I just want to be very clear about that. I don't think that, just as, I would say this, our argument is that there's a group of people who are assigned male at birth for whom being placed on the boys' team is harmful, right? We happen to have a word for those people. It is transgender girls. But I don't think that means that we're elevating gender identity to be the new definition of sex. Just as in Phillips versus Martin Marietta, there's a subset of women, who are harmed by the policy. Not all women, but there's a subset of women who had young children. And there's a name for them, it's mothers, but that doesn't mean that we're replacing the word sex with mothers. I think
How do you respond to or deal with the other side's characterization of that harm as just the disparate impact of this regulation? That really, it's not discrimination, I think they're saying, but it is just the downstream effect of the application of the classification that the Javits Amendment allows, and that's just the way it goes.
Yeah, so I guess I would say this. I think this court has dealt with the issue of things like constructive denials and constructive discharges in a variety of contexts. And under Title IX, an outright denial isn't required. Davis says a constructive denial it also counts. And whenever there's a question of constructive denials, the court applies a standard that's reasonable person in the plaintiff's position under all the circumstances. And they use that for constructive denials. You've used that for retaliation claims. And if you look at Burlington versus White, I think it's very on point here, because one of the points that Burlington versus White said is that there's some actions that aren't going to be harmful to most people, but they might be harmful to some people. So Burlington versus White used a mother with young children might find a change in her work schedule to be incredibly harmful, right? That doesn't mean that, we're arguing that, this is a disparate impact classification on people who have young children. It's a sex classification. The sex classification is just harming some people and not harming other people. So that's how we would view it. I think this is a facial sex classification any way you cut it. And
I'm sorry, you don't think we should have an operating definition of sex in Title IX? Now, I understand the idea that, the question then becomes not whether or not there's discrimination on the basis of sex, but whether there's discrimination on the basis of whatever characteristic you think should be included in the definition of sex. Now, when it's used as a statutory term, I'm not sure you have that kind of flexibility. The question would be instead, what does Congress think the word means?
Well, Your Honor, I guess I'd say I think Congress prohibited discrimination based on sex.
I'm sorry, go ahead.
Yeah, and so I don't think that, I don't think Congress adopted a definition of race, in Title VI in order to prohibit discrimination on the basis of race. I think I'm not trying to police the accuracy of the terminology that's being used. All I'm saying is that what's being prohibited is using this classification to discriminate, not.
So but without really knowing what the distinction is.
Well, I don't think the examples I've given about sex-based characteristics fall outside the common understanding of things that are related to sex.
Well, related to sex, I guess what you're saying is that we do have to accept for your position that we're not dealing when Congress says sex, we're not dealing with biological sex. We're dealing with other characteristics that people might associate with sex?
No. I think for this case, you can accept for the sake of this case that we're talking about what they've termed to be biological sex. I think that resolves this case. I was just talking about in addressing other potential cases.
So we don't have to say anything about the matter. You're willing for us to proceed on that assumption.
Exactly. Just like in Bostock, I think you can proceed for argument's sake without taking a definitive position here, because it might have downstream consequences in other cases that even the United States doesn't want the court to prejudge here. Now, I would like to say one quick thing on Justice Barrett's reference to separate classrooms. I mean, it is true, and the ACLU's litigated cases about theories that there's different brain sexes for women versus boys, and that's why you need separate classrooms. I think the instinct was completely correct that you can have a lot of scientific justifications for discrimination. That doesn't mean that the discrimination is allowed or immune from scrutiny. And in fact, some of the studies that are cited in the amicus brief say boys are naturally more aggressive, right, and favor competition more because that's in their DNA. So I do think even in these studies, the idea that you're completely, just basing it on pure biology and not on other generalizations doesn't quite hold up. I'd also, to the extent that we're we want to go back to Caban, I do want to just make a couple quick things clear. Caban was not a facial challenge. It wasn't. And neither was some of the First Amendment cases they were talking about weren't equal protection First Amendment cases. They were commercial speech cases. Michael M. also wasn't a facial challenge. He wasn't saying I should have an exception because a prepubertal girl was involved. He was saying the statute is overbroad because in theory it could apply to a prepubertal girl. So I do think that some of the characterization of the cases doesn't hold up to our reading of them.
So how does a Caban-type as-applied intermediate scrutiny analysis work in your view? It is an underdeveloped area of the law. Is it enough for one person to show that she bucks the trend or not?
Yeah, I don't think so. I think I agree with my co-counsel that I think we're talking about a discrete, definable group that will reliably not serve government's interest. And I don't think Nguyen is a counterpoint to that, because the whole point in Nguyen was that men who were not similarly situated had an opportunity to demonstrate that. There are three very easy methods of transmitting citizenship. And Nguyen emphasized that in order to do it, those were minimal burdens. And that is the key fact in Nguyen that distinguishes it from this case. This is a categorical ban. And Nguyen and Caban and all the court's cases distinguish between categorical bans and more narrow procedural requirements that do treat men and women differently, but still provide the opportunity for demonstrating that you're not similarly situated.
I think a hard question that Ms. Hartnett got, maybe the hardest question on these lines, was if we recognize these sorts of as-applied challenges, doesn't that effectively turn intermediate scrutiny into strict scrutiny? Right. What would your answer be to that? Would it be any different, or do you want to elaborate?
I think the answer is it absolutely wouldn't. You still are only looking for a substantial relationship, which means that you can have these sorts of requirements where there are a lot of under Caban and under Lair. There's still a lot of fathers that are out of luck, that they actually probably do have a good relationship with her kid, but they didn't fill out the right paperwork, they didn't do this, they didn't do that, and heightened scrutiny doesn't require that they be excused from those procedural burdens. So I do think that heightened scrutiny allows you to have procedural requirements that people have to go through, and those can be enforced. Strict scrutiny does not allow that. But that's different from saying that if the complete rationale for a classification just doesn't apply to you, that there's no equal protection claim you can bring. And some of it's complicated to talk about the difference between facial and as applied post-CASA, because I think a lot of the things that we called facial challenges now would be viewed as overbreadth challenges, right? Where someone is trying to say the law is so overbroad in general, it has to all be struck down. And we have that for First Amendment. I don't think we have that anymore for most equal protection claims. And so I think taking this facial as applied framework from before CASA, where we allowed these facial attacks on statutes, and then just transporting it into as applied cases post CASA doesn't necessarily work. I think some of the terminology might need to be rethought. And so, again, that's another reason why there's not a lot of precedent in this area, as several of you all have acknowledged. And that's another reason why I don't think this should be the case that makes that precedent when it's unnecessary to do so.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
Would you address a little bit the quantum of certainty or uncertainty that would have to exist in the science? Your co-counsel, or the counsel in the other case, said that if it's 50%, the state loses. But I'm always hesitant about these percentage cases because it's never qualitative. It's never quantitative, it's qualitative. So what do you think the qualitative standard is?
Well, I mean, to be clear, I don't actually think there's uncertainty in the case of someone who's had puberty blockers and then gender-affirming hormones. Our position is there's zero uncertainty. It's actually clearly in our favor. So but in general, I think it's hard to give, a quantitative answer to that. I think part of heightened scrutiny involves taking all of these factors into account. This court, has said on several occasions that heightened scrutiny can accommodate deference. And I think I honestly think it's a case-by-case decision that also looks at how harmful the classification is, how burdensome it is. I don't think you just look at the accuracy of the classification and add a number value for how certain we are that it's accurate. I think many other factors come into play.
Justice Kagan? No. Justice Gorsuch? Justice Jackson? Thank you, counsel. Rebuttal, Mr. Williams?
I think you've now heard respondent abandon the Fourth Circuit's logic on Title IX, and I think in many ways that makes this court's task that much easier. Congress authorized regulations allowing sex-separated athletics. West Virginia's definition of sex tracks the ordinary meaning in 1972 and 1974 and the regulatory framework that Congress endorsed. I think, Mr. Chief Justice, your question really highlighted how BPJ's approach unmoors the statute and the regulation under Title IX on the basis of sex. BPJ's test in turn begins to look more towards other characteristics that aren't on the basis of biological sex, and I think that's not consistent with what we see there. I also think the answer to Justice Barrett's question reflected how under BPJ's theory this really isn't about competitive advantage. Really what this does turn on is gender identity, because BPJ continues to maintain that a cisgender boy who continues to not have those same biological advantages would nevertheless still be kept off of the girls' sports team. So if you endorse that philosophy, that would require the court to hold that long-standing Title IX athletic regulations are unlawful. It would eliminate sex-separated athletics entirely, and I think it would defeat Title IX's core purpose of ensuring equal athletic opportunity for both sexes. On the equal protection side of the House, the question is whether the classification is substantially related to an important governmental interest. And I think that BPJ ultimately wants to rewrite the classification to be something that it is not. Biological sex substantially relates to athletic performance. That's exactly why, in fact, Title IX regulations authorize sex-separated teams in the first place. Respondent's test effectively ratchets up the intermediate scrutiny standard into a perfect fit, best disposition case that this court has repeatedly said is not the standard under intermediate scrutiny cases. That is the standard for strict scrutiny cases. You have heard it several times today. Justice Sotomayor, you asked about deference. I think this court has also repeatedly recognized that in areas of evolving science and medicine, especially involving children, legislatures have the primary responsibility for weighing competing evidence and making the policy judgments. I think the court just recently said that in Scrimeti, but I certainly don't think that case stands alone in recognizing that, especially when you have competing balances of harms, Justice Kavanaugh, when you're weighing these sorts of zero-sum games, that's a choice, that's a policy judgment that ultimately rests in the hands of the legislature. In the end, this court has, quote, recognized physical differences between men and women. They are enduring. Inherent differences between men and women are cause for celebration. That is all that West Virginia's law does here. It should be upheld. Thank you.
Thank you, counsel. The case is submitted.
Good afternoon, everyone. My name is Karen Lowy. I am Senior Counsel and Director of Constitutional Law Practice at Lambda Legal, and I am so proud to have stood with my colleagues in representing BPJ and her mom. Today, we had a chance to explain to the court what it really means in concrete terms to deny a kid the opportunity to access all of the things we want our kids to be able to access as they grow and become fully realized adults simply because of who they are, simply because they are transgender. That equal opportunity for our kids to grow and thrive is what our laws and Constitution demand, and that is what we are all here to fight for and will continue to fight for, and we are grateful for the opportunity to make that case to the court today.
Thank you very much.
Kevin Jennings, I'm the CEO of Lambda Legal. We were proud to be co-counsel in Becky's case. What this is about is something I learned as a high school teacher 40 years ago. Every kid has a right to play. Every kid has a right to belong. Every kid has a right to be treated equally. Becky Pepper Jackson is an American hero because she stood up for millions of other kids today and said, we belong, we matter, we are equal. Thank you, Becky.
Thank you very much. What is your definition of sex?
I don't think that's what's at issue in this case. What's at issue in this case is fair treatment for all kids. Sorry. Oh yeah. I was just saying I don't think that's what is at issue in this case. What's at issue in this case is fair treatment for all people, including cis people and trans people, and that's what we're here to talk about today.
Great. Thank you very much. Thank you very much. Sure.
Let's try again.
for coming out here on behalf of ACLU, Lambda Legal, Trans Law Center, GSA Reform. But every single one of you get all over from many states, and we're very grateful for you for standing for our trans youth, for our queer youth, and our LGBTQ youth, and for all children, because they all deserve to have the same opportunity. We're very grateful. Big applause for all the volunteers. The team, the cheers. We're very grateful for you all. Please have safe and smooth travels back home and bring this fire to you. What's there is an equal opportunity.
In 2019, I was proud to stand with many of you on these very steps.
So now, please have a safe, and we're going to
versus Clayton County.
Going safely back to our buses and our routes.
Doreen Denny from Concerned Women for America.
Okay. Thank you so much for coming. We're very grateful. And Ambassador Mariah from Trans Law Center. Thank you so much.
Authoritarian nonsense that is gender identity has all been documented.
And muchas gracias from all our communities. When we are together, we win. When we are together, fight for the team. Fight for the team. Thank you so much. All right, I think we've said all that needs to be said. We have inspired, we have stated facts, we have stated reality. But listen, today is not the time, will not define who we are. The justices will not ever define who we are. The opposition will never define who we are. Lawmakers will never define or get to decide who we are. We're going to keep fucking here like Miss Danger was saying. We're still
What do you want to call?
Hello, Michael Gold. How are you doing? How are you? He calls you son? He can't call you bro? Why not bro? I call you bro. Oh, okay. Sounds good.
Check one, check one. This is a sound check. Check one. Anybody need a bounce? Check one, check one. Yeah, here you go. Good. Check one. Got it, got audio? All right.
I mean, I waited and it's more important. chatting with your colleague, I guess. Did not know when this? Didn't know what? Didn't know about this? Oh. As I said. Start 1 or 2 minutes. 1 or 2 in the morning. Which one? 1 or 2. Take your pick. Thanks. Hard 1 or 2, just not 1.
Thank you all for being here. As the Deputy Chair of the Progressive Caucus, I am grateful to have our members united to ensure the Department of Homeland Security faces accountability. Last week, the nation watched an ICE agent shoot a Minnesota resident in broad daylight. Not once, not twice, but 3 times. I am beyond heartbroken and outraged that the Trump administration's actions led to Renee Nicole Good's murder. Her final words before being shot were calm and non-threatening. She said, "That's fine, dude. I'm not mad at you." Those are the words of someone attempting to de-escalate, not someone posing a lethal threat. After the shots were fired, the agent is heard saying, "Fucking bitch." This did not happen in isolation. This was not an accident, and it was certainly not inevitable. This killing is the direct consequence of deliberate choices made by Donald Trump and his administration. Over the last few months, the president has repeatedly inflamed tensions, espoused hateful rhetoric, and intensified attacks on Minnesotans, especially the Somali community. ICE's increasingly violent actions have terrorized our state and culminated in this needless loss of life. This is what happens when you give people with guns impunity. Dangerous things take place. To be clear, demanding accountability is not radical. Calling for systematic reforms are not extreme. This is the bare minimum required to restore safety and justice back to our communities. The American people deserve answers and accountability. They deserve to live without fear of federal agents acting as judge, jury, and executioner in our streets. And so today, I am glad to announce that the Congressional Progressive Caucus has adopted an official position to hold ICE accountable. Our caucus members will oppose all funding for immigration enforcement in any appropriation bills until meaningful reforms are enacted to end militarized policing practices. We cannot and we should not continue to fund agencies that operate with impunity, that escalate violence, and that undermine the very freedoms this country claims to uphold. ICE has no place in terrorizing Minneapolis or any American community. Together, we will stand united to ensure we put a check on the pattern of violence and lawlessness from this administration. Next, I want to introduce our whip, Congressman Chuy Garcia.
Thank you. As the whip of the Progressive Caucus, I am pleased to announce that our caucus has voted to oppose any appropriation to ICE and Customs and Border Patrol unless specific reforms are met. We believe in dignity, in justice, and accountability. ICE has acted lawlessly and recklessly for decades. It's only now that we have videos and the evidence. This isn't a new development, but now the problem has been supercharged. Led by Republicans, Congress has signed off on tens of billions of dollars for the agency. And just last year, Republicans gave DHS $170 billion for border and interior enforcement in the big ugly bill, including $75 billion to ICE. Since then, ICE and other DHS agencies have doubled down on brutal, targeted enforcement programs. They've tear-gassed children. They've ripped families apart. They've disappeared and detained lawful permanent residents and U.S. citizens. They killed Silverio Villegas Gonzalez and shot Marimar Martinez 5 times in Chicago, in my district, within just a few days. And they killed Renee Nicole Good last week in Minneapolis. This is what happens when we give a bottomless pit of money to the Trump administration, which prefers death and destruction to the health, safety, and well-being of our communities. I represent a community that's been one of the epicenters of terror, as Minneapolis is today, and brutally unleashed by ICE and CBP. A community that could use those $75 billion for health care, for housing and education. With $75 billion, we could make a meaningful difference in the lives of millions who are struggling with insurmountable costs of living. Programs to provide housing to families, child care for 6 million children nationwide, 2 years worth of Pell Grants for low-income students. So today, I'm proud to stand in strong support of the position that our caucus has elected to adopt, rejecting unaccountable funding to ICE and CBP. And I also encourage all members, Republican and Democrat, to join us in voting no against the weaponization and the militarization of the government against our communities. Vote no on government cover-ups and lies. No to giving more money to Kristi Noem and other DHS officials who spit in the face of congressional authority and public accountability. No to using taxpayers to fund terror, trauma, and death in our communities. No más. Insto a todos los miembros republicanos y demócratas a que se unan a nuestra bancada para votar no en contra del uso de las Fuerzas Armadas y la militarización del gobierno contra nuestras comunidades. Vote no contra los encubrimientos y las mentiras del gobierno, no a darle más dinero a Kristi Noem y a los otros funcionarios del Departamento de Seguridad Nacional que desprecian la autoridad del Congreso y la rendición de cuentas ante el público. No al usar de dinero de las contribuyentes para financiar el terror, el trauma y la muerte en nuestras comunidades. Ya basta. Next, I would like to introduce the ranking member of the Subcommittee on Immigration of the Judiciary Committee, Pramila Jayapal.
Thank you so much, Representative Garcia, and thank you so much, Chair Omar, for your incredible leadership and courage in this moment, and to all of the members of the Progressive Caucus for taking a very strong, bold, and necessary position on appropriations. We cannot continue with business as usual as immigration agents tear gas peaceful protesters, ram down the doors of residents in Minnesota and across the country, as they round up U.S. citizens, as they strip our rights one by one. Last week, we all watched in horror as an ICE agent killed Renee Nicole Good in the streets of Minneapolis. She is not the first person to die at the hands of a rogue agency. And nothing we say or do can bring back Renee or any of these other individuals. But we can demand change in their memory. We have to urgently pass legislation to roll back the excessive funding for immigration enforcement that was in the Republicans' big bad betrayal bill. And we cannot support additional funding for the Department of Homeland Security without seriously meaningful and significant reforms to the way that federal authorities conduct activity in our cities, our communities, and our neighborhoods. No more masked agents. No more ramming down our neighbors' doors without a warrant. No more threatening and intimidating the American people from exercising their First Amendment rights. They must end detention abuses by immediately ceasing the use of private for-profit detention centers. 35 people have already died in ICE custody just since Donald Trump came in. As the ranking member of the Immigration Subcommittee, I get a notice every time an official death, and that's just the official deaths, are recorded. And there are reports that people are being forced to sleep on the floor with cockroaches, fed food with maggots in it, and had medical care withheld. Anything for these private facilities to save a buck. And there must be independent investigations of lawlessness and violence by immigration agents and Border Patrol agents, and meaningful consequences for those who commit these acts of violence. Not a slap on the wrist, no impunity given to these officers to do whatever they want on our streets and just sent back out into the streets. This Friday, we will be conducting our 6th hearing of the Immigration Subcommittee Democrats in Minneapolis, St. Paul, with Representative Omar and the Minnesota delegation. And we will hear from people who have been directly impacted, and we will continue to demand accountability, because that is the thing that the American people want, and it is absolutely what we must do today. With that, let me introduce the incredible representative from the state of Illinois, Representative Delia Ramirez.
Thank you, Congresswoman. You know, as you're hearing my colleagues talk about what's happening in the streets, I really want to encourage you not to normalize this moment. You've heard a lot of what's happening over and over and over. And it's really easy for you to hear abduction, kidnapping, killing, beating, dying in detention. And if you hear it so much, at some point, perhaps, it may feel normal. None of this is normal. It's unconscionable. For the last year, Chicagoans and our neighbors across the country have been dragged, disappeared, beaten, abused, kidnapped, shot, murdered in front of their very own loved ones. And as Americans watch the violence and the indignity on their phones, on television, they've come to understand what so many of us already know. that the Department of Security is a threat to our collective safety. But I want to be clear. What is happening today in our communities, whether it's Minneapolis, Chicago, Oregon, North Carolina, LA, New York, New Orleans, and the list goes on, it's not an accident, nor is it new. You may be surprised by what I'm about to say, but DHS immigration agents, they're not rogue. Why? Because from its establishment, DHS and ICE has been empowered through a lack of oversight and too much latitude to violate our rights under the pretense of security and safety. Who is feeling secure and safe right now under the Department of Homeland Security? On January 7th in Minneapolis, Americans saw the danger of infusing unlimited resources into DHS's abuses of power. ICE shot U.S. citizen Renee Nicole Good in the face. But many of us have been talking about what's happening for a very long time. And we knew that unfortunately, at some moment, we would be here today, heartbroken and devastated, watching the number of people dying under DHS. So now we've plainly seen what they do with unlimited resources and unchecked power. Funding ICE only fuels our own destruction. We cannot assure our security by sacrificing our humanity, our dignity, our liberty. So what can we do? You've heard from my colleagues already. How do we protect our Constitution? We have to use Congress, appropriations power, to hold DHS accountable. Yes, and that means we must oppose new investments and demand policy change and reforms. It means we're not voting on a DHS package without any reforms, significant reforms. But I want to go further. We have to also impeach Kristi Noem. I want to go further than that. We need to prosecute the criminals in masks. We need to cut and claw back ICE's funding as natural consequences for DHS's disregard for the rule of law and violations of our rights. We have to use every single tool, including the power of the purse, to end the campaign of terror, because we brought ICE into this world. And we have a responsibility to decide what we do with it after. Let me just say a few added words in Spanish. Lo más importante que tiene que escuchar nuestra gente es que el caucus congresional progresista, aquí con nosotros, ha decidido tomar una posición muy formal. Como no pueden imaginarse, el Departamento de Seguridad Nacional quiere más dinero para secuestrar a nuestra gente, para matar a nuestra gente en las calles, para meterlos en cárceles, mandarlos a El Salvador y a otras partes del mundo. El Congreso aquí, el caucus progresista congresional, ha decidido que no votaremos por ninguna legislación que tenga más dinero para ICE, para el Departamento de Seguridad Nacional, que incluye también CBP, si no vemos reformas con contabilidad que sea en verdad concreto. Es muy importante que en este momento usemos todo lo que tenemos en nuestro poder para hacerlos a ellos contable. Y con este grupo aquí lo haremos. Muchas gracias. Con eso es mi gusto introducir. It is my pleasure to introduce to you. I'm Spanglishing it right now. I know the president will love that. The one, the only, our champion for immigrant rights in Florida, Maxwell Frost.
Thank you so much, Delia. Good afternoon. I'm Congressman Maxwell Alejandro Frost. I represent Central Florida in my town of Orlando here in Washington, D.C. Today, I want to speak about the choices Congress faces in the upcoming appropriations bills, the responsibility that we have on funding decisions that we make. And I'm very proud of the Congressional Progressive Caucus for taking this principled stance, because the one thing that we can do, that no one else in the communities that we represent can do, is walk onto that House floor and cast the ballot and cast the vote. And what we vote for and what we vote against is a true reflection of not just our character, but also our priorities and what we believe needs to happen in this moment. And as we see these videos and these accounts, as we see ICE in our community terrorizing our people, kidnapping Americans, human trafficking people across the entire world, our position is simple. We will not fund that. We say no to funding for any DHS appropriations bill as long as our people will continue to be killed in detention facilities, on our streets, in our communities, as long as this lawlessness continues. And this position is grounded in the reality of what's happening right now. 32 people have died in ICE custody in 2025. In 2025 alone. The agency's deadliest year in more than 2 decades. And in case after case, families and attorneys pleaded for basic medical care. Their loved ones died after being denied the treatment that they needed. In December alone, 6 people died in detention facilities. The pattern is accelerating, not improving. And just last week, Renee Nicole Good was shot, killed, murdered by an ICE agent in Minneapolis. She was a mother, a partner, a neighbor, a poet, a member of her community, and her death was preventable, and it should have never happened. Our nation is at a critical inflection point. When immigration enforcement results in the loss of life, whether in a detention facility or in our communities, it exposes deep failure in oversight, use of force standards, and accountability mechanisms. Congress cannot look away. Continuing to write blank checks without demanding change only will allow these tragedies to continue, and to be honest, it also means that we are complicit. That is why we are calling for clear, enforceable guardrails, stronger limits on the use of force, independent investigation when harms occur. We cannot depend on this administration to police themselves, and an end to the enforcement practices that are terrorizing our communities. People should not be afraid to go to work, to take their kids to school, or to simply live in their own neighborhoods because of how immigration enforcement is carried out. But I'll be honest, without us doing this, we cannot depend on this administration to do anything. I mean, hell, if they didn't care when gunmen walked into our elementary schools and murdered children on the floor in cold blood as they were there to learn, why the hell would they care about Renee Good? If they don't care when people go into our synagogues and our temples, when people go into our churches and murder our people in the middle of the street, just so the gun lobby can make more money, why would they care about the United States government doing the same thing to our people? That is why Congress must assert itself and step up. And the last thing I have to bring up is just the callousness of our leadership in the White House right now. That no matter what your political beliefs are, that an American died. She was murdered. Need I say executed by a federal agent who looked her in the face, looked her in the eyes, and then shot her in the face. And as her car turned into a casket and rolled away uncontrollably and hit a pole, he called her a fucking bitch. And then the president and the vice president and Kristi Noem take to social media, take to their podiums to tell the country that she's a domestic terrorist. And then my colleagues on the other side of the aisle have the audacity to take to social media, to take to the oversight committee to say, well, hold up. We got to let the process play out to know what happened. Trying to gaslight us from what we saw with our very eyes. Of course, everybody deserves due process. You know who didn't get due process? Renee Nicole Good. She didn't get a shred of due process before she was murdered and executed by an ICE officer who obviously wanted to do her harm because he was mad, because he was angry, and he had a gun. And he used that gun to murder an American and a human. There is no leadership in this nation right now. It is a very dark moment. And I'm not going to hold my breath waiting for this administration to do the right thing. And so I'm proud of the Congressional Progressive Caucus for taking a very principled stand to say that we are not going to be complicit in the killing of our people, in the terrorizing of our communities, and we're going to do something about it. Without further ado, let me bring up my colleague, Representative Maxine Dexter.
Thank you all for being here and shining a light on this critical issue at a pivotal moment in our nation's history. I'm proud to stand here with my Congressional Progressive Caucus. I am Maxine Dexter. I am a mother, a physician, and very proud U.S. Representative for Oregon's 3rd Congressional District. Details are still emerging, but one thing is absolutely clear. When any law enforcement officer fires a weapon in any community, the public must have answers to questions. They must have accountability and transparency. Transparency cannot be optional. Accountability cannot be optional. And due process is not just not optional, it is foundational to the priorities of our nation, to the principles of our country. There was a time when the American people could trust the federal government. We could believe that they were upholding principles and our laws, and that they would share information based on facts, not spin or propaganda. That time is past, folks. That's why I'm grateful to Oregon's Attorney General, who has launched an independent investigation to gather facts without political interference. This independent investigation is so critical because, as you have heard, there's a disturbing pattern across this country, from Portland to Minneapolis to Chicago, where masked federal agents act without fear of being accountable to the law. This impunity, this type of conduct, has led to U.S. citizens being detained and assaulted. It's led to wrongful deportations. And last week in Minneapolis, it led to the murder of a mother and a poet, Renee Nicole Good. We're here to say this is not normal. We are taking a stand against it, and we will stand against anyone who will not abide by the laws and the principles of our nation. The Congressional Progressive Caucus will oppose any appropriations bill that funds immigration enforcement without meaningful and actionable reforms that ensure transparency and accountability to the law. No blank checks, no business as usual. It is horrific that I must say this in the year 2026, but I will every single day until it is reality. Our communities deserve a federal government that is accountable to the law, that is committed to keeping them safe, that won't murder them in cold blood. Nothing else will do. Thank you. I yield back now to our Deputy Chief or Director. Oh, sorry.
Or something or other. I'd like to open it up for questions, and Ryan from NBC was first person to ask to. So please.
Yeah, Kyle from NBC. Wanted to ask, have you had a chance to talk to Leader Jeffries yet about this position from the Progressive Caucus? And also, do you have confidence you'll be able to keep the full Democratic caucus united against DHS funding?
We have had the opportunity to dialogue with him and with Democratic leadership. Democratic leadership understands what is going on. They are very concerned, and they also share our sentiment that we need to do something to bring reform, to bring change, to stop the lawlessness, the cruelty, and the abuse of power that's taking place within ICE and CBP and DHS. Yes, sir.
I'm curious, many of you talked about needing significant reforms in order to support a DHS funding bill. I'm curious if you can add some specificity behind what, are there any specific provisions that are red lines that if you all don't see them, I'm just looking to get some clarity on what you all mean by
I'd like to start with ranking member of our Judiciary Committee talk about that.
Thank you. The Immigration Subcommittee, Democrats, we have been putting together a list of what constitutes meaningful reforms. Some of them you may have heard of, some of them you may not have, but obviously things like not wearing masks, requiring a warrant for an arrest, the private detention facilities, the issues that we've been seeing with the federal government not sharing information with state law enforcement officials around independent investigations for accountability. So there are a number of things that we have identified that have that are really all critically important because the abuses are so widespread and occur in so many different places. We have to address all of them. And I think I think it is important for us to understand that one small fix to some meaningless provision is not constitute serious accountability. And I will say that the Judiciary Committee and Representative Garcia, critical member of that committee, we have turned, this is our second hearing, I'm going to go back right now, in Judiciary that has become a hearing on Minnesota. Because every bill that they try to bring forward has nothing to do with the real issues that we are dealing with, but we have forced the Republicans on the committee, because every Democratic member has stood up and said, how can you watch this? We have played the videos. We've done frame-by-frame analysis. We are not going to rest until we have that real accountability, and we will not vote for these appropriations bills that do not include that kind of significant reform and accountability.
Let's go to this side. Yes.
How many Democrats do you anticipate will support your all's proposal to not support any ICE funding?
I don't have a precise number on that, but we feel very strongly as a caucus. The vote was overwhelming, nearly unanimous, I believe. And two, we've heard from all quarters of the Democratic caucus, members who are very concerned about what's transpiring, understand that DHS is out of control, that the abuses are pervasive and throughout, and that it needs to stop. So we know that there'll be additional support from other caucuses.
And if this means, we have another government shutdown because you guys, don't approve of this funding, what is your message to Democrats and to lawmakers?
Well, we're not ready to talk about a government shutdown. We're talking about an issue that's captivating the nation and the need for reform of an agency that's received so much money that they don't know what to do with it. And the more that they have, the more that they'll spend, the more the abuses that will occur on American citizens and other individuals. Yes.
If you propose defunding ICE, then how would you deal specifically with illegal immigrants who do have criminal backgrounds in the U.S.?
Look, the law is clear on the removal of such immigrants who may have criminal records. We're not opposed to that. What we're opposed to is the trampling of constitutional rights, the racial profiling, the use of masks, the use of the deadly use of force, the disrespect that agents show in our communities has never been inflicted on any community in recent history. And that's what really is at the heart of all of this. You can't be treated like dirt and not protest and not be outraged about what's happened. Yes.
Thank you. Similar to that question, but if funding or authority even for ICE is reduced, who ultimately fills that enforcement gap, and how do you reassure the American people that these changes won't end up shielding the criminals?
I'll defer to a ranking member.
Look, I want to be very clear that what's happening right now is the Trump administration is taking away law enforcement that should be focusing on real national security threats, on real criminals, and deploying them to immigration and harassment, kidnapping, detention, killing of U.S. citizens, residents, undocumented immigrants who have never committed any crime in this country. That is what's happening. 25% of FBI agents have been deployed to this. Homeland Security Investigations, which is HSI, part of ICE, used to focus on real criminal investigations. And even those of us who didn't like what ICE was doing used to support many of those investigations that HSI used to carry out. Those were important investigations. HSI is now working on this. And you may have seen the news that the prosecutors who at the Department of Justice who are responsible for the so-called fraud investigation in Minnesota just stepped down and resigned because this is being used to go after immigration, go after people in the state of Minnesota just randomly. And today we played the video in Judiciary Committee of doors being battered down. I just want to remind everybody that the Fourth and Fifth Amendments of the Constitution apply to everybody, citizens and non-citizens alike. So I think we have to actually look at this and turn your question the other way and say, do you care about actual national security and public safety? Because what is happening right now is undermining the safety and security of all Americans across this country.
Go back to this side. Yes.
Can I add something?
Oh, sure.
Just real quick, everyone should be aware that progressives in Congress are the crime fighters in Congress. And this isn't just like a talking point that I'm making up. We have a record on this as well. Donald Trump does not care about fighting crime. He doesn't care about keeping our people safe. What does the record show? Bipartisan Safer Communities Act, putting forth an Office of Gun Violence Prevention, making sure that we fund agencies like ATF to actually go after secondary and black market guns and ghost guns. And guess what? It worked. For the past 3 years, the last 3 years of the Biden administration, gun violence that went down the most it's ever gone down in our nation's history, including homicides by gun. What are the first things that Donald Trump did? Gut ATF. Get rid of crime gun intelligence. Get rid of the Office of Gun Violence Prevention. Scale back community violence intervention work. All these things that were supported in many cases in a bipartisan effort, Trump got rid of. Yeah, and pardon insurrectionists and pardon people. So I just think it's important to know that for a lot of time, those on the right here in Congress want to use crime and talk about safety as a political point to win an election. Then they get into office and they don't do anything to actually make our people safer. They try to use it for their own agenda. We have passed legislation that has resulted in less people dying and less crime being committed. Those are the numbers. And they don't care about how Donald Trump feels about them. Because every life saved, and behind every number, there's a human. And we get that. So if you want to ask somebody about crime, please ask congressional Republicans and Donald Trump why they're fine with gutting the ATF, why they're fine with completely stepping away from making sure that we do something about the black market of guns and ghost guns that are hurting our communities and that are out there killing our people.
That's community safety. Yes.
Thank you for taking my question. Oh, sorry, Congressman. Did you want?
Sorry, I was
just on, I understand your position related to DHS appropriations bill is focused heavily on immigration enforcement and what happened in Minnesota. But obviously part of the DHS appropriations bill, it also funds the TSA, it also funds FEMA. And so when you guys make this position about not voting for a DHS appropriations bill that doesn't have reforms to ICE and those immigration services, how do those people like TSA agents and people who need FEMA funding factor into that, given, you know, TSA agents just work for over 40 days without getting paid during the government shutdown. So what's your message to those people if you're not going to vote for a DHS appropriations bill?
The greatest abuses and trampling of Americans' rights are occurring in the places that are in the news right now. No caucus is as pro-labor and pro-worker as is the Progressive Caucus. We have many, many champions in our ranks. We appreciate all of that. We think that the American public, especially new polling that was released, is in a new place about these abuses. They want it stopped. They don't want the types of tragedies that we've seen all over, and they're sickened by the trampling of people's constitutional rights and the racial profiling that is going on in communities. We're sensitive to that. What we're saying is, let's sit down, let's work out some reforms, and then we can talk about appropriations and votes. Yes.
Thank you so much. I have a question for Representative Omar, if that's okay. A question that I have, if you are, how are you coordinating with state and local officials in Minnesota to support affected communities in Minneapolis and St. Paul amidst these tragic events happening?
I mean, we have our staff that is in the district doing the constant work of making sure our congressional delegation, obviously the Democratic congressional delegation from Minnesota, and our local communities are getting information that is necessary, but also taking that information and seeing ways in which we could be supportive. Thanks.
I understand we have Michael from the New York Times here. Yes.
I wanted to ask, so you guys are talking about attaching meaningful reform to an appropriations bill, but as I'm sure you know, Secretary Noem, in a court filing on Saturday, suggested the sheer amount of money that was given to DHS during that reconciliation bill exempts them from an existing oversight requirement appropriations. So how do you contend with that as you're pushing for meaningful reform on a spending bill that she's already suggesting she has enough money to work?
You want to do it?
Okay, first of all, it's a BS argument. And hopefully the court is going to say that. Clearly, we have to spell things out even more than we have. But first of all, you can't make an argument that in that particular case of that detention, that federal facility, that is a federal building, as I understand it, Representative Omar. And you can't suddenly say that that was only funded by the one big bad betrayal bill. So it's not, we don't think we're in court around that. We don't think it's going to hold up. But what I would say is, why are Republicans refusing to have accountability for agents who go rogue? Why are they refusing to have an independent investigation into this? Why were they immediately out trying to classify what happened and lie about what happened and gaslight the American people who saw it with their own eyes? Because they don't want, and Kristi Noem herself, by the way, on CNN said, you can't trust the government. And Dana Bash said, you are the government. She said, I know, that's what I'm saying. So I don't think we can trust what they're saying right now, and it's an unfortunate thing, but I think we have to be aware that when we write the appropriations language, we're going to have to spell out even more clearly than we have what this applies to, and they can't try to draw this distinction between what was in the big bad betrayal bill and what's in appropriations. I don't think the court will see what the court does.
I also want to reiterate that 2 of the 3 shooting victims that have been in the news, the first one last summer at the end of June, Silverio Villegas, had just dropped his kids off from school. Same thing in Minneapolis. And the third one, the woman, my neighboring community, who was shot 5 times, Marimar, they also called her a domestic terrorist. The case fell apart. It was dismissed. They dropped the charges. They've used these labels on every single one of those instances, and that's reprehensible, unconscionable. Yes, sir.
I understand the official position is just related to the DHS funding bill, but if there aren't any reforms to ICE or changes to ICE policy, should Democrats oppose the other funding bills to try to force Republicans to the negotiating table and try to get some policy concession?
We have our position on this bill. We want to deal with that. We're ready to engage, and we're ready to negotiate. We'll take them one at a time. Yes. Nick? Oh, Nick.
Several of you have referred to the shooting of Renee Good as murder. There hasn't been, a complete investigation. Are you perhaps prejudging, the possibility of getting a fair trial for the shooter or his rights to due process by calling it murder before anybody's been charged?
Could I ask you a follow-up question? Would you ask that of the president and Kristi Noem when immediately they called the victim a domestic terrorist? That's right. And then they're going to be the ones that are going to conduct the investigation and ice out Minnesota from doing it? The reality is, as you see more and more footage, it is clear for us there was an intent to kill. I just did an interview with BBC with a former ICE director under Donald Trump, and we talked about the number of shots, and he said, it doesn't matter the number of shots. He was trying to justify it. Yeah, the number of shots matter. There was an intent to kill. And then he went further and called her a fucking bitch. So I think we can go back and forth on that. What we are saying is we want to see an independent investigation. The public is demanding it. And for the sake of our own credibility as government officials, whether you're Republican or Democrat, that investigation has to happen, because that investigation has been denied for Silverio Villegas, Gonzalez, and others. And the time right now is now, and we have an appropriations process to hold them accountable with.
And I will just say that the very first person that made a determination about this case was Kristi Noem. That's right. And then Donald Trump. That's right. So I introduced an amendment today on a judiciary bill to call for an independent investigation into this, because this is what our Republican colleagues kept saying last week during a hearing. We need an independent investigation. While at the same time they were backing up the fact that the very institution that should be calling for an independent investigation from the beginning. Imagine how different this would have been if Kristi Noem and Donald Trump had immediately said, this is horrific, a U.S. citizen was killed, we've seen the video, it is extremely disturbing to us, we are immediately launching, in conjunction with state law enforcement officials, an independent investigation into what happened. This whole thing would have, so I would just, I agree with Representative Ramirez. Ask the White House this question, because they are the ones that started this from the very beginning. We went back and forth in Judiciary last week with our Republican colleagues who wanted to analyze it. Great, let's have an independent investigation. They don't want it. They all voted against it today.
Mr. Wu?
Yeah, I wanted to ask, in recent days, some Democrats, Mr. Espaillat among them, have been talking about the need to terminate ICE altogether and rebuild it somehow again. Is that a sentiment that you agree with, going beyond mere conditions for ICE?
Nick, let me start, and members can feel free to chime in. I had never used the term abolish ICE until the last round of pounding that my neighborhood took when Greg Bobino and company showed up to terrorize our community. You know why I did it? Because my 8-year-old grandson, who is adopted, is terrified. All he wants to talk about is ICE. And when we drive around the neighborhood, is that ICE? Is that ICE? Is that ICE? Because my wife is terrified. And I, too, was sickened by the choppers flying overhead. I don't know if it was intentional, constantly hovering over my home in Little Village, while the terror that ICE was bringing to my community was all over the commercial strip of our neighborhood, Chicago's second magnificent mile in terms of commercial retail activity. That's when I said we can never go back to normal. People will never understand that ICE is an agency of the government, that it has legitimacy because of all the violence that they have perpetrated, all the terror that they have sowed, and all the disrespect that they have demonstrated against the people that I represent in Congress.
Thanks, everyone.
Certo, eu tô certo também.